The items for delivery of order, item number 36, IS Civil 3659 of 2022.
IA dismiss.
Item number 37, IS Civil 2328 of 2023.
Dismiss.
Item number 38, bail application 2561 of 2024.
Dismiss.
Item number 39, bail application 2714 of 2024.
Dismiss.
My lord, my two cases from 2021 is not listed. I do mention that may be listed on 3rd October.
Not possible. After vacation.
After vacation.
Yes.
The motion matter Miller, yesterday filing number is there. So might either Monday or Tuesday.
Tuesday is holiday perhaps.
Right.
Tuesday, oh no, Wednesday holiday. Tuesday. Tuesday. Okay, Tuesday we will try.
May I please?
Yes.
We have to mention for listing, my lord, one the MSc appeal, it is delay is condoned, but the appeal is not admitted, my lord.
When do we want?
My lord, it may come on 3rd of.
After
Third.
vacation, third.
Is there any urgency?
Agents, my lord, if they admitted, then the 50% may be released. That's in need of some money.
Okay.
I'd like to mention item 10. Council for a petition is out of session. It's the matter on 4th of October.
4th of October.
4th of
On the pair being made by learned counsel for the petitioner, SSL is the matter. The other side not entered a variance.
new matter.
New matter. Okay. SSL is the matter on 4th of October.
Okay.
May it please your lordship, I beg to mention for listing of an MSc appeal to come up for orders, my lord.
When?
Since the matter was not listed.
No. When do you want?
Tuesday, my lord.
Tuesday.
Thursday.
It's after vacation also.
Is there any urgency?
Urgencies, my lord, we are for the claimant, but since 1 year it was not listed, my lord.
Okay, 3rd of October. Okay.
The consent of the other side, I beg to mention item number 23. Kindly, my lord, matter may be listed after a week.
The vacation lordship. I'm for the other side.
Item number 20?
23.
23. Your good name?
B. Sharma.
Miss B. Sharma, learned counsel appearing on behalf of?
M. Talukdar.
Pardon?
M. Talukdar.
M. Talukdar name is not there in the counsel list.
Petitioner 1, 2, 3.
With concern from the other side, for listing the matter when?
The vacation
After
After vacation. Okay. Fair.
May please your lordship,
Yeah.
I have to mention listing for IS civil lordship.
When?
Yeah, 1 October, 1st October.
1st of October.
True.
Okay.
May I please your lordship? My lord, item number 5 may be taken up at 2 p.m. My lord, my senior advocate has gone at Dr. Chamber.
Okay.
May it pleases your lordship.
Mm.
Lordship, I am praying for listing of one matrimonial appeal, lordship. Can it be on any date before vacation, lordship?
Before vacation, not possible.
Lordship, there is some.
Only after vacation.
If it is possible on 3rd of October.
No, sorry.
Lordship, there is some urgency because the appellant herein, he was directed to pay the maintenance and the amount was too high. So it has become difficult for him, lordship.
No, only after vacation.
21st on the first.
DPOB.
May it please your lordship, I beg to mention MFA 44/2024. Lordship, the matter was supposed to be listed after 31st July. However, the matter has not been listed yet. Any date may be granted, lordship.
After vacation, you can choose any date from him.
Much
Under
obliged.
which category?
Hmm?
Under which category?
Railway claims.
No. Motion orders hearings.
Admission. May it please your lordship, I beg to mention two more MFAs. Both are, one is of 2016, other one is 2021. Both of them not listed in.
After vacation.
Much obliged.
Lordship, I would like to mention an MAT appeal before vacation.
No, no.
Lordship, there is an urgency because notice has not been issued.
Maybe before vacation, not possible.
Notice has not been issued, Lordship.
Pardon?
Notice has not been issued, only for issuance of notice.
Okay. Possible.
Before vacation, how could it, so many cases already. On the very first day, on 21st October.
Obliged.
Top of the list matter, item number 1.
When of this MFA has been preferred,
Hmm.
against the judgment and order, it is passed by dated 31st/3/2003. In my Workman case number 283 of 2001.
You are for appellant,
I am for the appellant, I am the insurance. I am the insurance company.
insurance company. What is the ground?
Ground, my lord.
Because only
I,
the
I will not,
Hmm?
from the, my lord, this is substantial question of law, which
Hmm.
are involved in this case, my lord.
where it is framed?
It is, my lord, in page 7 of my memo.
No, in the order. Who is that?
Yes, my lord. Order, my lord, the basic fix is, my lord, this.
No, no. I'm asking you, by which order of this court a substantial question was framed?
When of the initial, when the one of the petition is filed, the subsequent question is to be, my lord, form and that to be along with the petition, my lord. On the basis of that, my lord, that was.
Hmm? No
Probably it's the
substantial
first-
question
first
was
order.
framed.
That is the
No
first.
such order.
This is my lord.
So in your memo of appeal, where you have suggested the substantial question of law.
It is what I have mentioned in this paragraph, page 7 of my.
Hmm.
That is the-
But at the time of admission, did you point out to the court that here substantial question of law
Yes,
has to be framed?
Yes, my lord. Without this substantial question of, my lord, framing this. that,
No,
my lord,
show me where the court has framed it.
My lord, this is a procedure, my lord. Without the substantial question of law. framing
No,
this
you
sub-
cannot argue on that point now. Because the order does not reflect any such substantial question of law.
Which order, my lord?
Order of the court,
This Honorable High Court, my lord.
yes.
That was, my lord, the initially from the first day, my lord, this is on the basis of this substantial question, my lord, petition is to be filed. Otherwise, I cannot file.
Hmm.
This is to be framed by
But
me.
show me where is the question of law, substantial question of law?
I have mentioned in my page 7 of the my memo of appeal, my lord.
Hmm.
But the court order, it is not reflected on the basis of that, my lord, that is admitted or not, my lord.
Hmm.
But without this, my lord, I cannot file. Workman compensation against I appeal any appeal, my lord, that to be on the basis of the substantial question of law. And palpably, my lord, the order of the workman compensation is very much, my lord, erroneous because the loss, my lord, they, my lord, loss of earning, my lord, capacity and the injury is not the, my lord, synonymous. By that, the court came to the conclusion that as in my own words, that the 30% disability, so accordingly, my earning capacity is 40%. But on what basis the 30%, my lord, disability is occurred, it is nowhere because neither it is a permanent nature nor it is a temporary nature. It
No,
is
the doctor was examined by the court.
doctor was examined, but he was not an orthopedic, he was a dermatologist.
Hmm.
He was a dermatologist doctor. So dermatologist doctor, how he can certify it is a person is my lord, he is because of this injury, he is not able to do the work. My lord. The doctor, he was PW2. He is not the orthopedic doctor. He is a dermatologist. And not on the basis of the trace in examination. That is on the examination that was long back. On the issued by the one orthopedic doctor is exhibit my lord 5. He my lord ratified this content of the documents.
Show me the medical certificate issued by the doctor. Is it part of this memo?
LCR was called for LCR problem.
I'm for the play-by the discuss.
Hmm.
Regarding LCR also,
Hmm.
this matter was last listed on 26th of September 2023,
Hmm.
when the matter was fixed for hearing. And during the hearing session, Lordship, this honorable court found
Oh.
for a moment, if your Lordship peruse the order dated 26/9/2023,
Hmm.
passed by this honorable court.
Hmm.
Here,
Photocopy of this I can think so.
paragraph 2, may I read, Lordship, the order?
Okay, not necessary.
Yes, it is the documents which is necessary for proper adjudication of this case
Hmm.
was not available in the LCR. So this honorable court directed the trial court to send the all documents immediately,
Hmm.
as the matter is pending since 2003. Thereafter, Lordship, there is another order, 26 April 2024,
Hmm.
passed by this honorable court.
Hmm.
Here, Lordship, in the second page, Lordship, below, Lordship, the second paragraph,
Hmm.
Lordship may kindly peruse.
Hmm.
In view of the above, the commissioner of the Your Lordship,
Hmm.
this part is there.
Hmm.
So again, they failed to submit the original document before this.
Hmm. Hmm.
Thereafter, there is an order passed by your Lordship
Hmm.
on 7/8/2024,
Hmm.
where it is marked as flag N,
Hmm.
the reply sent by the communication sent by the trial court,
Hmm.
where it is mentioned that there is no original documents with them. They have all sent everything to this honorable court way back in 2016
Hmm.
as per the requisition, and they have only some photocopies of the record as a dummy file.
Hmm.
And when today morning also I have examined, verified the records of LCR, and I found that original documents are not in. Even PW1 and 2 is also not available here.
Evidence.
Evidence only the photocopy is available with me.
Hmm. Photocopies are available here also.
Yes, yes.
No, whether that certificate of the doctor is available with you.
No, that is the already well put the record.
No, origin is not available.
That is not available with me.
Hmm.
Whatever copy was and document was furnished from the insurance company, I have relied on this in file. Probably, well, there was no any original document that was relied by the claimant, but that is not by me. That is the exhibited of the claimant's document, my lord.
Now you come to the point, the amount awarded is may agree.
My lord.
The amount awarded by the commissioner is may agree.
Lord, because the manner of assessing the loss and the earning capacity, it is not proper, first of all. And second thing, 12% interest.
No,
It is also
this
not,
assessment of income.
it is not
So
only
in absence of any proof of document.
No document. Only
No, that's all right. But the court can assess the income
But there is a one anomaly is there
Hmm.
because
Hmm.
the relation of the principal and the servant, that is also not established because the owner only filed his written statement.
Hmm.
After that, he did not turn up to depose any evidence, nothing was there.
Hmm.
So that is also not established.
Hmm.
That is also not established that he is an employee of mine at the time of the relevant time. And 12% interest also, it is very much observed because the Supreme Court as well as our High Court also saying this is a simple interest. 12% interest is a high amount. Why I am only taking to indemnify the claimant on any accident. But it does not mean that any liability with me. I am not liable for anything. If something has been given, that I will indemnify. And that is
Okay,
from
now you tell me, can you tell me what was the rate of interest at the relevant point of time awarded by the national bank, nationalized banks?
that is maximum 9%.
9%.
9%.
Now, are you agreeable to pay 9% interest?
Even my lordship is given my lord that 9%. I have nothing to say. But as per my submission, my lord,
Hmm.
why I should pay interest, my lord?
Hmm.
Is there any fault on my part?
Hmm.
If I any negligence on my part to satisfy the award,
No,
that is a
no,
different.
Mr. Mohanto, you see, and now we have the original records are not available before this court.
Yes, my lord.
And I don't think that it could be traced out also. So find out one
My lord, that can be interest portion
amount which are agreeable to both the parties, which is agreeable to both the parties.
because my lord, the one thing
Hmm.
lordship have to verify this from the document also lordship will satisfy, I think.
Hmm.
The injury, my lord.
Hmm.
Injury that should be either permanent or partial or whatever mean. But the injury may sustained by the claimant,
Hmm.
it is not reflected as either is a permanent nature or a temporary nature. It is just a tenderness.
Hmm.
Tenderness on the bone. Tenderness on the bone doesn't mean that this is a partial or permanent nature of injury. And this is that too by on the basis of a doctor who is not a orthopedics, he is a dermatologist. So dermatologist lordship, our High Court also saying that whenever the assessment is to be clear, whether the loss of earning and loss of injury to be, that is on the basis of some medical strict examination. In Jain Sharma, Honorable Justice, he also in a given judgment, the 2000, and the recent judgment also by our High Court in Honorable Justice Surana also, that is also the same criteria followed. That the medical examination that should be on the basis of some criteria that to be fulfilled. In recent judgment, that is Lordship Bajaj Alliance Insurance Company versus the Pratap, yes, Prasad Kalita. That is also in that judgment, Melody Pratap Narayan Singh case also relied in Supreme Court, that was also relied in this case. Pratap Narayan Singh also very much clear, the medical examination is to be strictest proof. That certain amount of injury I sustained, that either may be permanent or be partial, or may be permanent or temporary, whatever it may be. But this document never saying anything. So, my submission is the amount, whatever is given.
Mr. Mohanto, you see, the evidence of the doctor is available here. But nowhere in the cross-examination you have challenged that medical.
No, that is there.
Where?
Cross-examination, we have said we are not the fit, proper, he is a dermatologist, you are not an orthopedics, my lord. That is there in cross-examination. He admitted that I am a dermatologist. It is German. His doctor name is Dr. Punananda Boda, my lord. মই রূপেশ্বর নেও চিকিৎসা দুৰ্গেশে নাগক চিকিৎসা কৰিছিলোঁ। তেওঁ মোৰ ড্ৰাইভাৰ বুলি পৰিচয় দিছিল আৰু তেওঁ চলোৱা গাড়ীখন দুৰ্ঘটনা হৈ তেওঁৰ জখম হোৱা বুলি কৈছিল। তেতিয়া তেওঁৰ বয়স 29 বছৰ মান আছিল। মই যেতিয়া চিকিৎসা কৰিছিলোঁ তেওঁ মোক প্ৰাইভেট ট্ৰিটমেণ্টৰ কাগজ পত্ৰ দেখুৱাইছিল। প্ৰদৰ্শ 1 প্ৰদৰ্শ 2 মই আগতে দেখিছিলোঁ। প্ৰদৰ্শ 3 মই দিয়া প্ৰেছক্ৰিপশ্যন। প্ৰদৰ্শ 3 মোৰ চহী। তেওঁ কি জখম হৈছিল প্ৰদৰ্শ 3 মই উল্লেখ কৰিছিলোঁ। তেওঁক মই অৰ্থপেডিক চাৰ্জনৰ লগত কনচাল্ট কৰিবলৈ পৰামৰ্শ দিছিলোঁ। প্ৰদৰ্শ 4খন অৰ্থপেডিক ডক্টৰে তেওঁৰ পৰীক্ষা কৰি দিয়া কাগজ সেইখন তেওঁ মোক পিছত দেখুৱাইছিল। প্ৰদৰ্শ 5 মই দিয়া চিকিৎসাৰ প্ৰমাণপত্ৰ আৰু প্ৰদৰ্শ 5(1) মোৰ চহী। প্ৰদৰ্শ 3 মই ৰোগীজনৰ শাৰীৰিক অক্ষমতাৰ হাৰ 30% বুলি মতামত দিছোঁ। এই 30% শাৰীৰিক অক্ষমতাৰ বাবে উপাৰ্জনৰ ক্ষমতা 40% হ্ৰাস পোৱা বুলি মই লিখিছোঁ। মই 30% শাৰীৰিক অক্ষমতা আৰু ইয়াৰ ফলত তেওঁৰ গাড়ী চলোৱা ক্ষমতা হেৰুওৱা ক্ৰছ মই মেডিচিন ডাৰ্মেটলজিষ্ট আৰু STD বিষয়ে অভিজ্ঞ। প্ৰদৰ্শ 1ত ফ্ৰেকচাৰ হোৱা বুলি লিখা নাই যদিও POPৰ জখম দেখিছোঁ যিয়ে ফ্ৰেকচাৰ সূচায়। মই প্ৰদৰ্শ 3 এখন 35 বছৰ লিখি পিছত দাবীদাৰ হোৱা মতে কাটি তেওঁৰ বয়স 29 বছৰ বুলি লিখিছোঁ। তেওঁৰ হাতত মণিবন্ধন 4/6/2001 চনত পৰীক্ষা কৰোঁতে কোনো ফ্ৰেকচাৰ হোৱা নাছিল। এই সত্য নহয় যে অৰ্থপেডিক ডাক্তৰ এজনতকৈ মই ডিজেবল চাৰ্টিফিকেট দিবলৈ কম্পিটেণ্ট নহয়। Everything is there. And moreover, he says that there is a fracture injury I have seen, but fracture injury is not a permanent nature or temporary nature. That can be healing at any moment. And if the doctor, where this High Court as well as Supreme Court saying the doctor certificate is with a proper certificate, the competent person has to issue the certificate. He is a dermatologist. Otherwise he is saying that I have advised him to consult with the orthopedic, and otherwise he is giving the certificate.
He stated that the certificate of orthopedic doctor was produced before him.
But there was no mention of anything, my lord. Before him, but what is the content?
No, that's why that certificate is not available before the court.
But the judgment, but the award is given on the basis of his document. That's Exhibit 5, where he is saying that the 30%, accordingly his earning capacity is 40% loss. On what basis, my lord?
No, the percentage of disability may vary. And in one of the recent judgment, Rajbir Singh or Rajesh Agarwal like that.
I am also relying on the judgment, my lord. Where it is specifically said.
But you see, this judgment is of in the year, which year?
This is in 2003.
2003. But most of the recent judgment in MSCT are passed later on.
Yes, some later on I realized some 2000 also. Our Honorable Justice Jain Sharma. And recent judgment also I am relying the High Court passed by the Honorable Justice Surana, my lord. My humble submission is this, my lord. Anyway, this judgment is not a good judgment.
No, maybe.
So this award, on the basis of that award cannot be, my lord. This amount. And moreover, the certificate, my lord, how it is initially he said 35 years, then he when objected, then he written is 29. That is also one, because factor was taken, my lord, 29. my humble respectful submission, my lord, the document that is to be relied to decide the, my lord, disability and the earning capacity, it is a doctor document, my lord. And if the doctor document is not at all satisfactory, my lord, this judgment will come. If it is satisfactory, then I have nothing to say, my lord.
No, to derive that satisfaction, the document is not before the court now.
That is true, my lord. Then the lordship have to decide on the record, whatever is available now. Because
Yes.
the document is, the evidence portion is also there in support of that. Evidence is saying that I have only issued the certificate and exhibit 5, saying that his disability, physical disability 30%. So accordingly, his earning capacity, loss of earning capacity is 40%. But one basis by 30%. There should be some basis, my lord. That he is not able to move the legs, or he is not able to move the hands, anything. That to be there. Tender days is, my lord, what type of things, my lord? I don't understand. If somebody is saying
And
that even
let us say the evidence of the victim.
yes, my lord. Yes, or no, my lord. This is one. Wherever we see he is saying, মটৰ দুৰ্ঘটনাত আঘাতপ্ৰাপ্ত হোৱা বাবে মই এই গোচৰ কৰিছো যোৱা 3/6/2001 চনৰ তাৰিখে ৰাতি 1:30 মান বজাত
No, 7:30.
it is my lord 7 is my lord missing, so it is just
7:30.
yes, yes. So 7:30 7:30 মান বজাত
Rangolo.
ৰাহুল হুটাৰ
Rangolo Hutar Gaon.
গাঁৱৰ দবকাৰ পৰা নগাঁও অভিমুখে গাড়ী চলাই আহি থাকোতে গাড়ীৰ আগত পৰা মানুহ এজনক বচাবলৈ ব্ৰেক মাৰোতে গাড়ীৰ ব্ৰেক ফেইল হৈ গাড়ীখন ৰাস্তাৰ কাষলৈ চুচৰি গৈ ৰাস্তাৰ কাষত বেকা হৈ পৰে। দুৰ্ঘটনাৰ ফলত মই ড্ৰাইভিং চিটৰ পৰা গাড়ীৰ ভিতৰত পৰি গাড়ীৰ পৰো। দুৰ্ঘটনাৰ ফলত মই কান্ধ আৰু বাহুৰ মণিবন্ধনত আঘাত পাওঁ, মূৰতো আঘাত পাইছিলো। দুৰ্ঘটনাৰ পিছত মই পুলিচ থানালৈ গৈছিলো। পুলিচে মোৰ বিৰুদ্ধে ফৌজদাৰী গোচৰ লয় আৰু মোৰ ড্ৰাইভিং লাইসেন্স চিজ কৰে। মই চলোৱা গাড়ীখন নম্বৰ ইমান মিনি বাছ। গাড়ীৰ মালিক শ্ৰী দিব্যজ্যোতি বৰা। তেওঁৰ নগাঁও চহৰৰ বিভিন্ন ভাড়া ঘৰত থাকে। মালিকে মোক মাহে 1500 টকা দৰমহা আৰু দিনে 50-60 টকালৈ দৈনিক ভাত্তা দিছিল। দুৰ্ঘটনাৰ পিছত 4/1/2001 তাৰিখে মই নগাঁও চিভিল হস্পিটালৰ বাবে গৈছিলো। 1501 মোৰ নগাঁও চিভিল হস্পিটালৰ OPD ডক্টৰ শ্লিপ। তাত মোৰ কাণ আৰু হাতৰ মণিবন্ধৰ এক্সৰে কৰিবলৈ দিয়ে। 1502 মোৰ এক্সৰে ৰিপৰ্ট। তাৰ পিছত মই ডক্টৰ পূৰ্ণানন্দ বৰাক প্ৰাইভেট ক্লিনিকত দেখুৱাম। ইজ PW2 1503 ডক্টৰ পূৰ্ণানন্দ বৰাই দিয়া প্ৰেছক্ৰিপশ্যন। তাৰ পিছত ডক্টৰ পূৰ্ণানন্দ বৰাৰ পৰামৰ্শ মতে মই হাড়ৰ ডাক্তৰৰ ওচৰলৈ যাওঁ। 1504 ডক্টৰ জি দাস অস্থিৰোগ বিশেষজ্ঞই দিয়া প্ৰেছক্ৰিপশ্যন। 1505 পূৰ্ণানন্দ বৰাই দিয়া চিকিৎসাৰ প্ৰমাণপত্ৰ। 1506 এক্সিডেণ্ট ইনফৰমেশ্যন ৰিপৰ্ট। দুৰ্ঘটনাৰ ফলত হোৱা জখমৰ বাবে মই এতিয়াও গাড়ী চলাব পৰা নাই। মই বৰ্তমান বহি আছো। বৰ্তমান মোৰ বয়স 30 বছৰ। It is also discriminative মানে।
Hmm.
মোৰ বিয়া হৈছে, ল'ৰা এটা আছে, মোৰ মাও জীয়াই আছে। মই অকল মোৰ উপাৰ্জনৰ ওপৰতে নিৰ্ভৰ কৰে মই 2 লাখ টকা ক্ষতিপূৰণ বিচাৰি গোচৰ কৰিছোঁ। ইন ক্ৰছ মই দুৰ্ঘটনাৰ দিনাখন দুৰ্ঘটনাগ্ৰস্ত গাড়ীৰ পৰা পলাই গৈ 4/6/2001 চনত নগাঁও চিভিল হস্পিটেলত ভৰ্তি হওঁ। মাহৰ মই ডাক্তৰক দেখুওৱা নাছিলোঁ। প্ৰপাৰলি ডক্তৰ যি থাকে মোক পৰীক্ষা কৰি মোৰ বাহুৰ হাড় ভঙা বুলি কৈছে। মই এক্সৰে ইয়াত দাখিল দিয়া নাই। মোৰ চিভিল ডাক্তৰে এক্সৰে কৰিবলৈ দিছিল। মই মোৰ চিভিলত জমা ৰখা নাছিল। চিভিল হস্পিটেলৰ পৰা ঔষধ পাতি লৈ সেইদিনাই চিভিলৰ পৰা গুচি আহিছিলোঁ। ডাক্তৰে মোক ভৰ্তি হ'বলৈ কৈছিল, মই নহ'লো। ডক্টৰ পূৰ্ণানন্দ বৰাৰ ওচৰলৈ মই নিজেই গৈছিলোঁ আৰু ডক্টৰ জি দাসৰ ওচৰলৈ ডক্টৰ বৰাৰ পৰামৰ্শতে গৈছিলোঁ। মোক চিভিল হস্পিটেলৰ ডাক্তৰে কোনো ডাক্তৰৰ ওচৰলৈ যাবলৈ কোৱা নাছিল। সত্য নহয় যে মোৰ দুখন জখম কমোৱাৰ কাৰণে মোক দৰৱ দিয়ে চিভিল হস্পিটেলৰ পৰা পঠাই দিছিল আৰু অন্য ডাক্তৰৰ ওচৰলৈ যাবলৈ পৰামৰ্শ দিয়া নাছিল। জেছমিন ফাৰ্মাত এক্সৰে কৰিবলৈ মই নিজেই গৈছিলোঁ। ডাক্তৰৰ পৰামৰ্শ পোৱা নাছিলোঁ। মই চিভিলৰ ডাক্তৰৰ সাক্ষীলৈ মতা নাই। মই বয়সৰ কোনো প্ৰমাণ পত্ৰ দাখিল কৰা নাই। মই ক্লাছ 10লৈ পঢ়িছিলোঁ। এইটো সত্য নহয় যে মই 1500 টকা মাহে দৰমহা দৈনিক 50-60 টকা ভাত্তা পোৱা নাছিলোঁ। মই মালিকৰ সাক্ষী মতা নাই। মই মালিকৰ পৰা দৰমহাৰ কোনো প্ৰমাণ পত্ৰ দিয়া নাই। মই মালিকৰ দুৰ্ঘটনা সম্পৰ্কে কোনো লিখিত নটিচ দিয়া নাই। মুখেৰে কৈছিলোঁ। মই মালিকৰ মিলনপুৰৰ ঘৰত মই মোৰ ট্ৰিটমেণ্ট কৰাৰ কথা মালিকক কৈছিলোঁ। তেওঁ মোক ট্ৰিটমেণ্ট নকৰিলে। এইটো সত্য নহয় যে মোৰ গাড়ী দুৰ্ঘটনাৰ কোনো জখম হোৱা নাই। This was his cross and sif. So X-ray report that was he also said that was also not produced. And everything that was subsequently brought. Whatever is done, that was subsequently done and that was subsequently brought. So the original document that is been not produced before the court for making any decision before the time. So my assumption, the case is not based on any, whatever the judgment was given, the pronouncement of the award is given. This is not based on any of the reliable evidence. It is only the exhibit 5 that is being issued by one dermatologist, not by the orthopedic doctor. And he simply saying that I given the certificate that he injury is 30%. So accordingly, his earning capacity is 40%. And court came to the conclusion. And accordingly, the judgment was passed and awarding the amount. My submission, my lord, this award is totally erroneous. That should be, my lord, interpreted by the honorable court because 12% interest also not acceptable. I am here to indemnify the person concerned. If something is to be paid in meeting any accident or anything has happened to the worker. So in that is the liability of satisfying the interest is not with the insurance company. And that to the extent of the 12%. And that award has been given from the date of the accident. And entire, whatever medical examination was done, that was by his own, not based on any police requisition or anything. He admitted that after the accident, I fled. I went to see.
So you come to the calculation part of the judgment.
Yes, madam.
40% into 1800 into
Yes.
209.92.
Yes, madam.
It's rupees 1800, where it comes from?
I don't know, my lord. He is saying that I am getting 15%. That is also not proved. Master, my lord, the principal and the servant relation also not established. Court came to the conclusion that 1800. I don't know, my lord. That is also one of the ground. And that is factored also on the basis of the age 29.
Yes, 1800, 1800,
No, this factor 2091.
209.
Yes.
So, is there any factor in the workman compensation?
Yes, my lord, the age, my lord, the percentage of disability, my lord, this is as per schedule 4. As per schedule 4.
Hmm.
The,
Okay,
yes, my lord. Of the workman compensation.
workman compensation method.
My lord, this is the old act, my lord. This is now it has been changed.
Now it's employees
Employees
compensation.
Acha, okay.
Earlier that was workman compensation,
Workers'
now it is, my lord.
compensation. Now it is termed as employees.
Okay,
That to be, my
after,
lord, 2019-2023 act, my lord.
it may be available in our library.
Probably one of the some comparison chart may be there in this, I think, this one section. I can provide you the book, my book.
Okay. And what are the other points raised by you in the
But
appeal?
no, only the 3 points, but I have raised by only 3
That,
points.
one is that is
This is a
medical
casework,
certificate.
casework, my lord. This is not based on any conclusive test or anything.
Mm.
And second thing, well, a doctor, he was, well, who has given the certificate, he is not competent to issue that certificate.
Mm.
And third one, my lord, the employees and that relation was not there. So accordingly, that court cannot come to the conclusion he was a employee and is doing the salary of 1800. And the age, my lord, whenever he has stated the 30, and doctor say the 35, and as per his instruction, I am written the 29. And taking the factor of 29, that is also not proper, my lord. And the interest portion, my lord, this is very much exaggerated, and that cannot be 12%.
Okay.
Must have been.
Yes.
And my rely, my lord, judgment, my lord. This is one of the honorable our High Court judgment, my lord, James, my lord, that is in reported, my lord, 2002 GLT.
Furnish a copy.
I furnish copy. And another, my lord, the honorable High Court, my lord, the recent judgment passed by the honorable.
No, recent judgments are not required. It was old case.
I problem.
Yes.
Okay. In this case, the appellant insurance company raised the vital question and important question that whether the medical doctor, which was examined by the court, was a person who is competent to issue a certificate for depose before the court, because he was a dermatologist.
Mm.
And as per my learned friends' attention, that the nature of injury should be treated by a orthopedic, not by a dermatologist.
Mm.
If your lordship peruse, I have the new act, lordship. Maybe in the old act, maybe the same thing is mentioned. The employees' compensation in 1923. I'm going to read, lordship. Lordship, section 11, lordship. Medical examination. Here it is mentioned that where an employee has given notice to an accident, he shall, if the employer before the expiry of 3 days from the time at which service of the notice has been effected, offers to have him examined free of charge by a qualified medical practitioner, lordship. Here it is mentioned that qualified medical practitioner. Nowhere in the act, I have not found here. If my learned friend found it, that he may assist this court. Nowhere I found that here is it is specifically mentioned that this sort of injury should be treated by a specialist. Here it is mentioned that a qualified medical practitioner, and he must be registered under the law, under a particular act, for a state government or central government, lordship. So if a doctor is qualified medical practitioner, a dermatologist is also a doctor. So if the insurance company have any objection regarding his certificate and all, and lordship, and when my learned friend reading the evidence of the witnesses, of the mainly the claimant lordship, I found that he categorically mentioned that as per the advice of this dermatologist, he went to some doctor, Mr. Z Das, and he also go for a pharmacy for X-ray, and he adduced some documents also before the court. So at the time of cross-examination of the claimant, the insurance company already in their knowledge that he also went to a orthopedic doctor for his treatment. His name is also available in his witness. So at the time of their lordship evidence, whether the insurance company file any application before the court to call that orthopedic doctor or to call any document, because in this particular case, the insurance company didn't deduce any evidence. They choose not to deduce any evidence before the honorable court. In this regard, lordship, I'd like to rely upon a judgment of the honorable apex court. Page number 5 is relevant. A small paragraph I'd like to read, lordship. In that judgment also, honorable apex court relied upon a judgment of the honorable apex court passed in year 1999, lordship. In Vidyadhar versus Manik Rao. Lordship, get it? That's a small observation.
Page number?
In the page number 5, lordship will find in the lower portion. I marked it by my pen. Lordship will get in page number 5, internal page, lordship.
Yes.
Where a party to a suit does not appear in the witness box and state his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. So if the insurance company have a different story, if they want to contradict with the veracity and the contention of the claimant, then they could have adduced their own evidence. But here the insurance company failed to do so. And regarding the earning of the claimant, whether he was earned 1,500 rupees per day plus 50 or 60 rupees per day, which we call a khuraki like that in Assamese, whether he is altogether 3,000 rupees per month or not. In this regard, after receipt of notice, the owner of the vehicle entered appearance before the honorable court and filed his written statement. That was on record. On that written statement, he categorically mentioned that yes, he is my employee, my driver. He earned this much of amount. I paid him this much of amount. The accident was correct. He drive by vehicle. So the thing is that, lordship, if the
No, but that owner also, he also never entered in the witness box.
witness box, but
So
if
the
it's not
WS
correct,
committed by him, can we place reliance upon the same?
and then in this regard, lordship, if there is any doubt, then insurance company also call him as a witness to testify. His WS is there. They could have filed an application before the court that this man is necessary for proper adjudication of this case. Lordship. And in the judgment portion, lordship, if you are in internal page number 4 of the judgment, lordship, issue number 3, it is observed by the honorable court probably in the second paragraph, a small paragraph, lordship. On cross-examination, he denied the suggestion that his opinion about the disability of the patient was incorrect. The OP failed to disprove the contention of the claimant in merit. This is the observation of the trial court, lordship. And regarding 12% of interest, if you are thinking presently that now it is 2024, what is the rate of interest given by the nationalized bank? It is definitely 7.5 or 6%, 7.5 or sometimes 7.5% for the senior citizens. But if I can remember correctly, from 1999 to 2001 or 2002, the rate of interest was 12%. By the it is a offered by the Reserve Bank of India, directed all the banks to pay 12% interest, rate of interest to the fixed deposit or some like it's a rate of interest also in 2001. Now it is 2024. So regarding 12% of interest, lordship, I'd like to rely upon a judgment of this honorable court. Maybe it's not reported, but I have the copy. Exactly covered case, same sort of case, 12% interest, and it is the appeal filed by the insurance company is dismissed. by this honorable court also. It's MFA 9 of 2012. It's a 2012 case lordship. Here also 12% rate of interest was fixed. Insurance company, and they are also challenging the quantum and as well as the percentage, how they calculate the compensation amount. After appreciation of everything, lordship, this honorable court was pleased to dismiss the appeal and directed the insurance company pay the entire amount within a period of 1 month from the date of order, lordship. The insurance company during cross-examination of the witnesses lordship put some suggestions to the witnesses, but to prove that suggestion, they didn't adduce their own evidence. There is no evidence on record. In the judgment also, it is categorically mentioned that insurance company did not adduce any evidence in this case. So mere suggestions cannot be considered as evidence, lordship. We cannot accept it as evidence.
Okay.
And in this regard also, this honorable court, we have a final judgment of this honorable court. I'll provide a copy.
No, not necessary.
Yes.
Not necessary to multiply the decisions. So these are the points.
Yes. My humble submission before this honorable court is that since the matter is pending since 2001 and judgment passed on 2003, and on 2003 judgment also it is mentioned that the amount, the rate of interest of 12% should be calculated from the date of filing of the case, that is 3rd June 2001. So 12% rate of interest is reasonable. My humble submission is there because I am relying upon a judgment also. In that judgment also 12% is never altered by this honorable court.
Okay. Mr. Monto, this Xerox copy of the statement of the witnesses.
Yes, yes.
Please furnish to the court master.
Hello, the reply, my lord, I want to give the one with lord.
Yes.
Whatever he relied the judgment with us, this is, it goes against his mind. Because, my lord, the plaintiff, my lord, he failed to brought his evidence. That is, the onus is always with him.
Yes, yes.
That is, cannot be, my lord, bad upon the other side, that you have to prove, you have to liability, that cannot be, my lord. So this is my submission, my lord. And moreover, my lord, the doctor himself stated that I advise him to be the orthopedic doctor. That means that he is not competent. The orthopedic is the competent. So a certificate issued by him, this exhibit 5, that cannot be accepted.
Okay, we will see.
My lord.
This act with you and also the statement of the witness.
Yes.
Right.
Today I'll just file.
Okay.
After 2 minutes.
For Mr. Monto, learned counsel for the applicant, and Mr.
PP Borthakur.
P.P. Borthakur, learned counsel for the respondent. Argument concluded, judgment reserved.
Master.
Well,
Next.
For motion item number 2.
My lord, I filed this revision against the, my lord, impugned order, my lord, in page 94, my lord.
COVID. I thought civil will give out happening. No, I thought the civil court, the rule and practice will be otherwise. Yes. First you show me the report of the process server
My lord,
at page number.
my lord. Report to my lord, page 92, my lord.
So as per this report, you refuse to accept the notice.
That is their my lord contention, but I never received notice. My contention is that Jarikarov never visited my house and never handed notice, my lord.
No, he refused to accept notice. Therefore,
Yes, my
he
lord.
served the notice by hanging a copy of the same in the wall of your house.
Yes, that is the report of the Jarikarov, my lord. But my submission is that I have filed petition that Jarikarov never visited my house, and I have never refused to accept the notice. Otherwise, when case was
No, this report was submitted
madam.
by the staff of the court,
yes,
process server.
yes, but
Why should we disbelieve the report of the process server? You saw the ground.
my lord, and that my lord, if the my lord service of the process server is not sub, that is should be as per order 5 rule 17, my lord.
Yes.
Procedure when defendant refuse to access service or cannot be found, where the defendant or his agent or such other person as aforesaid refuse to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept service of summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door of some other conspicuous part of the house in which the defendant ordinarily resides or carries on the business or personally works for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon on annexed or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and whose presence the copy was affixed. So, process server, my lord, has been taken a signature, only one person's signature without giving the name, without the address, father's name of the my lord, that witness, my lord. Number one. Next, another thing, my lord, the trial court also failed, my lord, failed to appreciate the rule 19, my lord, order 5 rule 19. So Rule 19 says, my lord, examination of serving officer, where a summon is returned under Rule 17, the court shall, if the return under that rule has not been verified by the affidavit of the serving officer, and may, if it has been so verified, examine the serving officer on oath, or cause him to be so examined by another court touching his proceedings, and may make such further inquiry in the matter as it thinks fit, and shall either declare that the summons has been duly served or order service.
Which provision you are reading?
My lord, order 5 rule 19, my lord. Next page, my lord. After 17, next 19.
So,
That
as
was,
per Rule 17, it should be in presence of one person.
my lord.
Here, one Kasem Ali was there.
Oh, no, no address is given. No address.
No, the name of the place is given there below his signature.
Only name was given, then my lord, as per Rule 17, the address should be also given, my lord. Address also should be given. My lord, if I go through the Rule 17, my lord, again, last 3 lines.
Name and address.
Yes, my lord. Name and address. Name and address, only name was given, my lord, that was not identified the person.
Then rule 19.
Yes, my lord.
So this process server was not examined by the court.
My lord, that. Yes, my lord. Two things is given there, my lord. One pro affidavit and another is you should examine, my lord.
Heard, Mr.
M. Hussain, my lord.
Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 8/7/2024 passed in title suit number 8 of 2024. And also the impugned order dated 8/7/2024 passed in Mizze case number 2 of 2024 by the learned civil judge junior division number 1, Nagaon. It is to be noted here that by the impugned order dated 8/7/2024, the learned trial court has decided to proceed the suit ex-parte against the present petitioner. Mr. Hussain, learned counsel for the petitioner, submits that the respondent herein has instituted one title suit, being title suit number
My lord, 8/24.
8/2024 before the Court of Learned Civil Judge Junior Division, Nagaon. Wherein the learned trial court has issued summon to the present petitioner. Mr. Hussain further submits that the petitioner did not receive the notice, but he later on came to know about the same from one Ramzan Ali on 19/3/24 about the suit filed by the respondent herein, who was the said Ramzan Ali was the performer defendant in the suit filed by the respondent herein. Mr. Hussain further submits that having aware of filing of the case before the learned civil judge junior division, Nagaon, the petitioner appeared before the learned trial court and filed a petition on 28/3/2024 for vacating the ex-parte order and to allow him to contest the suit. But by the impugn order dated 8/7/2024, the learned trial court has dismissed the petition filed by the petitioner on the ground that on the basis of a report submitted by the process server that the present petitioner has refused to accept summon from the process server, and thereafter proceeded to hear the matter ex parte. Mr. Further, the learned counsel for the petitioner further submits that the impugned order is arbitrary and illegal, as the learned trial court has decided to accepted the report of the process server in contravention of the provision of Order 5 Rule 17 and Rule 19. And as such, the said order is illegal and arbitrary, and therefore it is contented to set aside the same and to allow the present petitioner to contest the said title suit. But having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record, and also perused the impugned order dated 8/7/2024. It appears that the learned trial court, on the basis of a report furnished by the process server, which is annexed with the present petition at page number 93, has decided to proceed the case ex parte against the present petitioner. It appears that the report of the process server is not supported by an affidavit, and also the said process server was not examined by the learned trial court as required by Rule 19 of Order 5 of the CPC. Thus, having examined the impugned order in the light of relevant provision as well as submission of learned counsel for the petitioner, this court is of the view that the same failed to withstand the legal scrutiny and therefore required to be interfered with. Accordingly, the impugned order dated 8/7/2024 passed by the learned trial court stands set aside and quashed. Consequently, the impugned order dated 6/3/2024 stands vacated, and the petitioner may be allowed to file a written statement. Have you filed a written
Yes, my lord,
statement?
already filed.
Already filed,
Yes,
and
my lord.
petition. Then
And
the
the
learned trial
mitigation
court is
is filed
directed
also.
to accept the written statement filed by the petitioner and thereafter to proceed in accordance with law.
And in Midday case also we filed, my lord, objection also.
Pardon?
In Midday case also we filed objection. Both the cases along.
Okay, both the order.
No, highly obliged.
At number 3.
May I please your lordship?
Yes.
My lord, this application has been filed against the rejection of the amendment of the written statement. A probate case was initiated in which the petitioner is one of the defendants. They contested the probate proceeding by filing written statement. During the pendency of that proceeding, she filed a petition for amendment of the written statement, which I have annexed at page number 23. And the proposed amendment is that paragraph number page 24, that the identity and the name of the so-called will is disputed. The declaration made by the so-called witnesses in the public petition are neither lawful and genuine. This much I want to add in my written statement. The learned court, additional district judge Dhuri, rejected on the ground that this is a file of a belated case and to fill up the lacuna. By this amendment, the nature and character of my defense will never change. Therefore, this order passed by the additional district judge Dhuri is apparently illegal and is liable to be set aside.
The impugned order is at page number 30.
30.
Where is the relevant observation?
Last paragraph.
Hmm.
It is well settled that no amendment of the written statement is permissible to bridge the lacuna of the concerned party. The respondent is expected to know that the proper identity of the witness who appended the signature in the will. If there is any dispute of such objection, was required to be stated in drafting the written statement and objection. No such stand has been regarding the dispute and identity of the witness while drafting the written statement. Moreover, at a belated stage, after the date of the witness in the year 23, and the other witness is terminally ill and died after 4 days, the filing of the instant application for amendment may be an attempt of the opposite party number 2 to bridge the lacuna of the written statement, which is not permissible. Accordingly, I observed that the opinion of the the opinion instant application for amendment is here rejected. That cannot be a ground for rejection of my amendment because
What is this the case was pending?
PW, they have filed the PW. It is in the stage of cross-examination of PWs. The Supreme Court, in a case versus LIC versus Sandeep Kumar, the Supreme Court held all amendments should be allowed. First stage, your Lexington is.
So the one condition is there. Provided it is necessary for determining the real question.
Yes.
Heard Mr. S.S. Sharma, learned senior counsel, assisted by Mr. Learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 3/8/2024 passed in Mize case number 03 of 2024, arising out of title suit within bracket P number 01 of 2023, pending before the Court of Learned District Judge Hubli. Learned Additional District Judge Hubli. It is to be noted here that by the impugned order dated so and so, the learned trial court has dismissed the petition filed by the petitioner under order 6 rule 17 CPC to allow him to amend the written statement. Mrs. Sharma, learned senior counsel for the petitioner, submits that the petitioner is the defendant in the title suit within bracket P number 1 of 2023, wherein he had already filed a written statement and the said case was pending at the stage of cross-examination of the PWs. Mr. Sharma submits that the petitioner white petition number where is the petition? Copy of the petition?
Copy of the petition is page number 23.
23. White is petition number 58 dated 10/5/2024 under order 6 rule 17 of the CPC. Press for allowing him to allowing her to amend the WS filed by her by incorporating one paragraph
As paragraph number 21.
as paragraph number 21 which is extracted here in below within inverted comma 21 that identity of the named witnesses in the so-called will is disputed. Full stop. The declaration made by the so-called witnesses in the probate petition are neither lawful nor genuine. Full stop. Inverted comma closed. Mr. Sharma further submits that by incorporating the aforesaid amendment, the nature and character of the suit, as observed by the learned trial court in the impugned order dated 3/8/2024, would never be changed, and that the observation made by the learned, no, and the ground assigned by the learned trial court for dismissing the petition is illegal and arbitrary, and referring to a decision of Honorable Supreme Court in the case of Life Insurance Corporation of India versus Sanjeev Builders Private Limited and another is reported in 2022 Life Law SC 729 submits that all amendments are to be allowed which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. Mr. Sharma further submits that by incorporating the aforesaid amendment in the written statement, no prejudice will be caused to the other side, and therefore it is contended to allow the petition. Where having heard the submission of learned counsel for the petitioner and also considering the facts and circumstances on the record, no, I have carefully gone to the petition and the documents placed on the record and also perused the impugned order dated so and so. And the decision referred by Mr. Sharma in Life Insurance Corporation of India within the gates of it appears that incorporation of the paragraph number 21 in the written statement submitted by the petitioner is necessary in order to determine the real question. In order to determine the real question in controversy, and the same would not cause any prejudice to the other side. In that view of the matter, the impugned order so passed by the learned trial court fails to withstand the legal scrutiny and required to be interfered with, and accordingly the impugned order is then set aside and quashed. The learned trial court is directed to allow the petition number dated so and so and to incorporate the paragraph number 21 in the written statement submitted by the petitioner. In director to proceed with the case in accordance with law. In terms of above, this CRP is disposal at this motion is itself.
Highly obliged.
Item 4,
Yes.
item 4,
Mid-page, Your Lordship. In this case, Lordship, the petitioners are the plaintiffs, Lordship. They are the decree holders. First of all, Lordship, their suit was dismissed, then an appeal was filed. That appellate judgment I have annexed as Annexure 1, Lordship.
No, the petitioners are.
Plaintiffs, Lordship.
Mm.
Their suit was dismissed, then they preferred title appeal number 34 of 2016, Annexure 1, page 10.
Mm.
That was remanded, Lordship, for fresh disposal.
Mm.
Page 12, Lordship.
Mm.
Para 10, it appears that the learned trial court discussed issue number 6 and reached the findings that the suit is not maintainable and dismissed the suit. The learned trial court had not discussed all the issues and had not given findings on all the issues. I consider that the learned trial court should have decided all the issues and should have given findings on all the issues. Although learned trial court discussed about the evidences produced by the plaintiffs and documents submitted by the plaintiffs, but has not discussed the same in issue number 6, which is whether the plaintiffs are entitled to get relief as prayed for, I consider it a fit case to remand back to the learned trial court for deciding each issue and give findings thereon. The case is remanded back to learned trial court to decide the suit afresh. The title appeal is remanded back to the court of Munsif Hatsingmari. The judgment and decree so is hereby set aside. Send back LCR along with a copy of judgment. Both parties are directed, Lordship. There is a direction to appear before the learned Munsif Hatsingmari on 30/7/2018 to receive instructions from the court. Accordingly, Lordship, I have enclosed the entire order sheet after remand, Lordship, page Annexure 2, page 14. Since 30/8/2018, Lordship, in all the dates they remain absent. Defendants' judgment debtors, Lordship. Thereafter, finally, on 29/6/2019, page 17, my suit was decreed, Lordship. May I read all the orders, Lordship?
No, not necessary. Let notice go at this.
Lordship. Thereafter, my case is that, Lordship, after again, when my suit was decreed, I have filed title execution. Those orders also I have enclosed as Annexure 3, page 28. Thereafter, Lordship, after 3 years and 3.5 years, they filed a title appeal, that is Annexure 4, page 43, along with a condonation application. So on the learned first appellate court, without registering a separate miscase, Lordship, in the title appeal itself, the condonation was allowed and appeal was also admitted on the very same date, Lordship, without giving any chance to the petitioners to argue on the admission of the appeal. So I am against that order, Lordship, that is impugn order Annexure 7, page 63. Your Lordship will find the condonation was allowed in title appeal number 1/2023, page 64 on 1/8/2024. Page 80 is the last portion that accordingly the petition number 218/2023 is allowed and disposed of accordingly without any cost. The title appeal number 1/2023 is admitted for hearing by condoning the delay in preparing the said appeal. Call for the HCR so and so for appeal hearing, Lordship. So I am agreed by this. Hence I filed this 227 application, Lordship. My prayer is to issue notice and stay the further proceeding of the appeal, Lordship, till their appearance, Lordship. As because their condonation application, very interestingly, Lordship, while they, Lordship mentioned the sufficient cause, they have given hampered on the illegality of the trial court also, Lordship. That the suit was decided ex parte without presence of the defendants, Lordship. In fact, there is a direct direction by the first appellate court at the time of remand that both parties should remain present on so and so, Lordship. Condonation application, if your Lordship.
There is the delay was condoned. It was considered in the main case, not
Yes.
in a separate case.
Lordship.
So what wrong with the trial court order, this appellate court order?
Lordship, in fact, Lordship, the delay application has to be registered in a mid-J case, Lordship.
Mm.
And after condoning the delay, appeal has to be numbered and thereafter appeal may be listed for admission hearing. As we are dealing in this court also, Lordship, if there is
No,
a
that is a different aspect, but the court has considered the matter,
Lordship, on this
considered the ground assigned for failing to file the appeal within
yes,
within stipulated period.
yes, Lordship, but no chance was given to the petitioners for admission hearing also, Lordship. This is the first appeal, Lordship. On the very same date, appeal was also admitted.
Okay,
in the-
heard Ms. R. Soduri, learned counsel for the petitioner. This petition under Article 227 of the Constitution of India, read with Section 151 of the CPC, the petitioner has put to challenge the correctness or otherwise of the order dated 1/8/2024 passed by the learned civil judge, Senior Division, South Salmara, Mankasar. In title appeal number 01 of 2023, it is to be noted here that by the impugn order dated so and so, the learned first appellate court has allowed the petition number 218 of 2023 filed by the respondents. Number 123 under Section 5 of the Limitation Act for condonation of delay of 3 years in preparing the title appeal number 2023. The learned counsel for the petitioner submits that the impugn order was passed without giving an opportunity of being heard to the present petitioner.
Moreover, I am not satisfied with the ground shown in their condonation application, Lordship. I have filed my written objection.
And as such, it is contended to set aside the impugn order. Having heard the submission of learned counsel for the petitioner, I have gone through the petition and the documents placed on record and also produced the impugn order dated so and so. Let notice be issued at this stage. Returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks. And having regards to the submission advanced by Ms. Soduri, learned counsel for the petitioner, and also considering the facts and circumstances on the record, the impugn order dated so and so stands till returnable date, list after 4 weeks.
Lordship, further proceeding of title appeal may kindly be stayed, otherwise the appeal will be heard, Lordship, and this petition will become infructuous, Lordship. I made it.
No, that order is stayed.
The impugn order, Lordship.
Yes.
Lordship, or the further proceeding of title appeal. Your Lordship has stayed the.
Is there any requirement
Lordship, has-
after staying the impugn order?
Lordship. Oblige.
Okay, I will say.
Indicated bail application, my lord, FIR is page number 10. The boy and girl are two young persons, my lord. The boy is about 19 years old. Page number 10. They eloped, my lord, from their house voluntarily. Page number 10. The age of the girl was actually 17 years, 11 months, well, 15 days. And the boy was about 20 years, my lord. 19 years, 10 months, the boy was, my lord. My lord, after 15 days of the elopement, my lord, they entered into a marriage agreement. I have annexed page number 17, my lord, after the girl attained majority, my lord. Page number 17, my lord. And they lived together for about 6 months, my lord, as husband and wife. Then the girl,
Let the city come along with the medical examination report of the victim.
yes, my lord, she voluntarily left to her parents' house and then produced to the, my lord, police, and statement recorded, and also before the magistrate, her statement is recorded, my lord. And my lord, page number 17 may be considered, my lord, for interim protection, my lord, of the boy, my lord. Page number 17, my lord.
Oh, we will say, let the city come first.
My lord, till the my lord, receive of the CD, my lord, and the statement of the girl, my lord. The boy may be protected, my lord. They lived 6 months, my lord, after entering into the marriage agreement.
Pardon?
They lived 6 months, my lord, as husband and wife, my lord.
Maybe,
And
maybe.
they, my lord, then
We'll say. Or Mr. Kadir, learned counsel for the applicant. This application under section 482 of the BNSS 2023 is prepared by the applicant Suhel Rana Sarkar alias Manik. Who has been apprehending arrest in connection with Agamone PS case number 5 of 2024 under section 365 of 34 IPC. Corresponding year case number 75 of 2024 for grant of PRS pay. Where is the petition? And also, where is the documents enclosed with the petition? In view of the submission of learned advocates about the parties, perusal of the case is found to be necessary, and accordingly it is provided that Mr. Locker, learned additional PP, shall party on
Immediately after reopening also, 21/10 also.
sorted. He has been apprehending arrest.
third,
Fourth.
okay.
Okay, third.
Yes.
Third.
Statement of the victim.
Also, Mr. Locker shall produce the statement of the victim girl recorded under section 164, corresponding section in BNSS. You do not know. You please go through the BNSS and inform the court master. Along with the medical examination report of the victim girl.
Item 40.
But on the last occasion, I was directed to file my Wakalatnama.
But now also your Wakalatnama is not available on the record.
But it is online, madam. I have filed the filing fee. Shall I submit, my lord?
So you were agreed by the order dated 9/7/2024.
Yes, my lord.
Whereby the learned trial
Yes.
court has accepted the written statement
Page 78, my lord. Yes.
beyond 90. Page number?
Page number 77, my lord. 17.
So the trial court has imposed cost of rupees 3,000.
My lord, that is there, my lord, but my humble submission on two counts, my lord. First one is this, my lord, that petition is heavily time barred. Your lordship would be pleased to see the petition was filed under order 5, rule 7, my lord. My lord, I will place the petition, my lord, at page 62.
Yes.
So, your lordship, petition was filed on 22/12/2022. So, this is the petition under order 9, rule 7. Your lordship would be pleased to see this order 9, rule 7. Procedure where defendant appears on the day of adjournment hearing and assign good cause for previous non-appearance. Where the court has adjourned the hearing of the suit ex-parte and the defendant at or before on the same date when the case was adjourned or before such hearing appears and assign good cause for his previous non-appearance, he may upon such terms as the court directs the court or otherwise be heard in answer to the suit as if he had appeared on that day fixed for the appearance. So, my lord, here what happened, my lord? Not before the date fixed, not on the date fixed, they appear, my lord. So, my lord, the ex-parte order was 26/11/2021. Now your lordship would be pleased to see the petition was filed on 22/12/2022 after more than 1 year. Now your lordship would consider that anyhow they did not appear before the date fixed or on the date, but this petition is to be filed supported by an application for condonation of limitation. That is not there. That is not there, my lord. If without limitation, this petition is allowed, my lord, that is abuse of process of the court. That is my number one decision, submission, my lord. And second submission, your lordship will go to order 8. Filing of the written statement, my lord. Your lordship rising in. It is to be filed within 90 days, maximum period. And my lord, in 16, there was an amendment that anyhow, it may be submitted after 90 days, that 120 days. That is within 4 months. But beyond that also, this written statement accepted by the court, my lord.
No,
Now-
that is permissible if sufficient cause is shown.
My lord, what is this?
120 days is for commercial suits.
My lord, here on sufficient cause, my lord, your lordship would be
Okay,
pleased to see.
Mr. Sheikh, we will examine the issue. We will pass the order regarding this limitation point.
My lord,
The other point you have submitted is it is a weak point. I don't think it will assist you.
sorry, my lord.
We'll pass the order.
My lord.
On the other day also, we have substantially heard you.
Yes, my lord. My lord. And exactly, my lord, this written statement was submitted on, after that order also, they did not submit the written statement.
Along with the petition.
Not along with the petition, my lord.
Thereafter.
Thereafter, my lord.
How many days?
They taken another time, my lord, and on 8/7/2024.
How many days?
My lord, about after passing of the order, my lord, order was passed on. Just 1 minute. 1/7/2024. And thereafter, my lord, this order that you can submitted on 8/7/2020. After taking another adjournment. Your lordship would be pleased to see the position. Here in the order, my lord, page 77. Page 77, order dated 5/7/2024. Parties are represented. Then, my lord, another date, my lord, 9/7, parties are represented. The defendant has deposited the receipt of issued DSL. The petition is accepted. Now the petition has been accepted. Written statement. Yes,
These are only 2 points.
my lord. Obligation.
Actually, here in this case, matrimonial course in the year 2019, lordship. Now the respondent hearing after receipt of the notice appeared in this case, and thereafter he cited the reason that he is having some mental problem, so he did not file the written statement. Now what has happened, lordship, 6/8/2024, he filed the written statement, and that has been accepted by the learned lower court, lordship, and I challenge this particular order. Because there was no application for condonation of delay. Why this written statement was not filed for last 5 years? And more to that, the initial reason that was cited for his mental condition, that was nullified by the report from the concerned hospital, lordship. I'm just referring to two such certificate, lordship, of the hospital. It is at page number, lordship. First one is annexure 8, lordship, page number 42. That was of 2023, lordship, 4th of August 2023. There's a report from the LGB Regional Institute of Mental Health. Page number 42.
It is an order. Annexure 8, Annexure 6, 7.
Lordship, annexure 8, lordship, page number 42.
42.
42.
42 is Annexure 7.
Sorry, lordship, 43. Annexure is the next page. The third paragraph, very much clear, lordship. The third paragraph, it has been mentioned by the concerned doctor. The patient was visited our hospital on such and such day and was off medication for a few months. As per the examination on 4/8/2023, the patient was found to be conscious, alert, partially cooperative. His eye contact was poor. A report was established. His speech was relevant with decreased productivity. His thought content revealed the persecutory ideas. The patient has no insight into illness. So there is a specific report with regard to the fact that the patient was not ill during the relevant period of time in the month of August, lordship. Thereafter, lordship, another report was called for by the
No, this report you see
lordship.
with a decreased productivity.
Exactly, lordship. Off medication and decreased productivity, that was of 2023. Now I'm coming to the next report, lordship. It is at annexure 13, lordship, page number.
And his thought contents reveals persecutory ideas.
The patient has no insight into illness. So that observation was also there. That was of 2023, August 2023. Now the next this report, this is of 2024, lordship, the annexure 13, page number 50.
Annexure
13, lordship, page number 50. Number 50, lordship. 2024, after almost a year. Lordship, got it? With reference to the cited above, Mr. Madhav Shoikia, son of such and such, has attended the medical board on 5/6/2024 with his brother. As per informant, he is without medication for last 8 months and maintaining his day-to-day work functioning without any complaints. As per the current mental status examination, patient is found to be conscious, cooperative, relevant speech with normal reaction time, intact orientation, intact judgment, and without any active
psychopathology. Considering the above, the board opines that he is currently fit to stand trial and he is advised to attend outpatient service if required. So his condition, his mental condition, almost 8 months back. His condition, because as per the report lordship of this particular 5/6/2024, that he was without medication for last 8 months and maintaining his day-to-day work, functioning without any complaint. So that aspect of the matter is very much there in that particular report. Now, what has happened, lordship, on 8/6/2024, lordship, the last order, 6/8/2024, the learned court below, lordship, accepted the written statement. Here in this case, lordship, the period of, lordship knows it very well, the period of 90 days is very much there. And when there is unexplained delay with regard to the filing of the written statement, there should be some application accompanying the written statement. There was no application as such explaining the delay in filing the written statement in view of the fact that, lordship, as per that report, if we take into consideration the report dated 5/6/2024, almost 8 months back, the report is very clear, lordship, he is without medication for last 8 months. And his condition, mental condition was alert and he was maintaining his day-to-day work, functioning without any complaint. So there is no such reason for not filing the written statement within this specific period of time. And the learned trial court, when I filed an application, it is at page number 54, lordship, that was not taken into consideration with regard to the fact that the written statement, the stipulated period not considered, and the fact that the respondent or the defendant there, he was just to delay the matter, he did not file the written statement. And acceptance of the written statement without any application for condonation of delay is nothing but abuse of the process of court, lordship. And there is a judgment of the Honorable Apex Court with regard to that. The written statement should not be accepted in a mechanical manner, lordship, if there is some delay.
That's all right, that is well settled. But when there is an explanation for delay,
Yes, there is no
that
explanation,
has
lordship.
also to be considered.
No, lordship, there was no such application filed explaining the delay in filing the written statement. This is the main point that I am raising before this honorable court, lordship. At least there should be some explanation that why the written statement was not filed within the stipulated period of time. On 6/8/2024, lordship, simply the written statement was filed and that was accepted by the learned law court, lordship, without calling for any explanation from the side of the defendant, lordship, to explain the delay. At least there should be some explanation that this is the reason why I could not file the written statement within the stipulated period of time. And the medical report speaks very much loudly that he was off medication for last 8 months, considering the month, this June 2024. That means from middle of 2023, he was off medication, he was mentally sound. So accepting the written statement without any application for condonation of delay is nothing but abuse of the process of court, lordship. And I am challenging this order 6/8/2024. Honorable Apex Court, there's a judgment, lordship, 2022 SCC, lordship. In that particular judgment, the Honorable Apex Court held that order 8 rule on CPC is directory. It cannot be interpreted to bestow a free hand on any litigant or lawyer to file written statement at their own sweet will or to prolong the lease. The legislative object behind prescription of timeline under CPC must be given due weightage so that the disputes are resolved in a time-bound manner. Inherent discretion of courts, like the ability to condone delay under Order 8 Rule 1, is a fairly defined concept, and its contours have been shaped through judicial decision over the ages. Illustratively, extreme hardship or delays occurring due to factors beyond control of the parties despite proactive diligence may be just and equitable instances for condonation of delay. So there should be some explanation, lordship, with regard to the delay, why the written statement was not filed. There is no explanation.
Is there any requirement of filing delay condonation petition?
Lordship, since the application was not filed, even in the written statement also, lordship, I have annexed the written statement. There is no explanation with regard to the delay in filing the written statement. There should be some explanation with regard to that, why the written statement has not been filed in the stipulated period. Because the learned lower court called for the medical report. As per that medical report, lordship, since June 2024, for last 8 months, he was mentally fit. And if that be so, lordship, if that report is to be taken into account, lordship, then he was not entitled to this to submit the written statement, lordship. There's a sheer negligence on the part of the defendant to prolong the litigation, lordship, and to cause undue harassment to the petitioner, lordship.
No, then what was the pair in this petition number 1828?
Lordship, the prayer in the petition, lordship, since 2019 the application was filed, and since that period of time no written statement was filed, The Indian view of the matter, considering the recent judgment of the Honorable Apex Court, that there was an irretrievable breakdown of marriage, the order of this divorce should be granted, Lordship. That was the prayer made before the concerned court, Lordship. And that was without any hearing. Finding, I have made a specific statement in my this revision petition also, Lordship. There was no hearing with regard to that petition. But the learned court below came to a finding, heard both sides on petition and successor under 151 CPC. And accordingly, that was rejected. Because irretrievable breakdown of marriage is very specific with regard to our application is concerned, Lordship. Because for last 6-7 years, there is no relation between the parties. And for last 4-5 years, he did not file the written statement countering the contention of the petitioner, Lordship. So on that ground, I filed that application, but that was also rejected without any specific reason. That since the written statement has been filed, so it cannot be taken into account. That cannot be a ground, Lordship, for rejection of my application, Lordship. And there was no hearing with regard to that. I made a specific statement in my petition also, Lordship.
No, there is direction in the order that both side are directed to appear in person to work out
No, that part is
possibilities
there,
settlement
Lordship.
outside the court.
That part is there. I'm not saying that it is not there, but prior to that, acceptance of the written statement is nothing but abuse of the process. Because of why I'm saying so, Lordship, because there is no explanation. At least there should be some explanation with regard to the delay in filing the written statement.
Okay, we'll see and pass the order.
Because Lordship kindly see this particular report, 5/6/2024, page number 50, is very clear that for last 8 months he is off medication and his condition is stable. So if that be taken into consideration, Lordship, from 5/6.
Prior to that, he was suffering from
Prior
some
to
kind
that,
of
I'm not
mental.
disputing, but for last 1 year, his mental condition is stable. So there should be some explanation the why he did not file the written statement for the last 1 year.
Okay,
Lordship.
okay.
Item
Excellent.
number 7, matters for admission.
Please, Your Lordship. That matter pertains to the provincialization of service of the petitioner, my lord. What happened in this case, my lord? Two schools, my lord, two schools were established having same name, my lord. I'll refer to my lordship to page 76, my lord, annexure 15 for a moment, my lord. 76, my lord. I filed a writ petition in the year 2014, my lord. This is a speaking order, my lord, passed by the Deputy Commissioner, my lord, Nagaon, my lord. And in the speaking order, my lord, lordship will kindly have a look. The relevant
Page number?
Page number 76, annexure 15, my lord. Yes, my lord. Thereafter, my lord, the concerned, my lord, additional Deputy Commissioner, my lord, Education, Nagaon, my lord. From that office, my lord, a hearing was conducted asking the petitioner as well as the private respondent to submit their particulars of the school, my lord. And accordingly, they had submitted all the particulars. And after a thorough observation and conducting a fair hearing, my lord, my school was declared to be genuine, my lord, in the original school, my lord. In the next page, my lord, the declaration has been made, my lord. Page 78, my lord, in the decision. Thereafter, my lord, I filed another writ petition, my lord, before this honorable court, my lord. Since my school was declared to be the original and genuine school, my lord, I filed another writ petition in the year 2021, my lord, with the prayer to provincialize my school, my lord, for the issuance of a direction to the respondent authorities, my lord. And accordingly, my lord, that writ petition was also disposed of with the direction to file an appeal under section 14 before the concerned authority, my lord. And I had preferred an appeal under section 14, but my lord will find at page annexure 20, my lord, page 87, my lord. I submitted an appeal, my lord, under section 14 of the Concern Act 2017, my lord. Unfortunately, my lord, no decision was taken by the concerned authority, my lord. As such, my lord, this petition was filed again, my lord, before this honorable court, my lord, with the prayer to provincialize the service of the petitioner, my lord. Thereafter, my lord.
No, after declaration of your school as genuine.
Yes, my lord.
by the additional deputy commissioner
Yes,
of
no government.
Nagaon. What happened thereafter?
Thereafter, my lord, no decision was taken by the concerned authorities, although my lord, the particular
Concerned authority, who is authority?
authority is the, my lord, I forwarded the particulars of my school before the concerned district officer, my lord.
Mm.
He had forwarded before the state level scrutiny committee, my lord.
Mm.
And the state level scrutiny committee, my lord, that is the MP order, my lord. My lord will find that page, my lord, 96, my lord. I'm sorry, my lord, 97 is the order, my lord.
Mm.
Annexure 24, my lord.
Mm.
The state level scrutiny committee had taken a decision on 28th of April 2022, my lord. My lord, will kindly have a look at the next page, my lord, page 98, my lord. The last paragraph, my lord.
Mm.
The SLSC examined the following points, my lord.
Mm.
Number one, as per clause 3.1, Roman 12 of the Provincialization of Services Act 2017, the enrollment shall be verified with the DIAS data as per DIAS code 2009-10 or before, maintained by National University of Educational Planning and Administration, New Delhi. Number two, on the other hand, government in elementary education department has constituted a joint sabha for examining the proposal for provincialization of services as per Act 2017. The committee, while its minute dated 24/7/2020, decided to instruct MD SSA to verify the following criteria in respect of the proposal submitted for provincialization of services. Number A, whether the name of the school appears in the DIAS data of 2009 or before. B, whether the name of incumbents appear in the DIAS data of 2011 and afterwards. Number C, enrollment position of the school during 2016-17 and 17-18. The next page, in view of the above, committee examining the stated facts is of the view that as school so-and-so with data with DIAS code number so-and-so doesn't fulfill the criteria as laid down in the clause 3.1 Roman 12 of the Act 2017, since the enrollment position of the school during the year 2016-17 is shown as no enrollment on UDIAS in the database maintained by NUPA for the year 2016-17. Hence, the committee decided to stand by the decision of the earlier SLSC and joint committee constituted by the government, and therefore the committee and also decided that the claim of the petitioner school for provincialization of services of the teachers against so-and-so school as per Provincialization of Services Act 2017 cannot be considered, my lord. Decision is thereby held against me, my lord. Now, my lord, the three criteria, my lord, have been, my lord, held by the SLSC, my lord. That was, my lord, from those three criteria, my lord, the first criteria was whether the school appears in the DIAS data of 2009 or before. I fulfill this criteria, my lord. That has been admitted by the concerned authorities. In fact, I have the inspection report and other communications also. My lord, will kindly have a look at page 84, annexure 18, my lord.
Annexure?
Page 96, my lord. Annexure condition. This is a, my lord, communication made by the, my lord, District Elementary Education Officer come District Mission Coordinator, SS, my lord. He has written this communication stating that, my lord, and regarding the DIAS code of my school has also been mentioned, my lord, here. May I peruse this, my lord? May I read this communication, my lord? With reference to the subject cited above, I have the honor to state that Honorable High Court Guwahati has issued an order against the Dakhin Podamoni Pathar LPS of Botodua block that Madam two parties as follows has claimed against the Dakhin Podamoni Pathar LPS headed by Azizul Haq. Number one. Number two is headed by Habibur Rahman. The Deputy Commissioner Nagaon has organized a hearing meeting of both parties, checked the original documents, etc., and issued a speaking order that the school headed by so-and-so is the original one. He is the petitioner with it. With DIAS code number so-and-so of 2009 and 10. The other school headed by Habibur Rahman is not original school. So DIAS code may be either be renewed or issue a fresh DIAS code to the school headed by so-and-so. This paragraph is important, my lord. What happened in this case, my lord? I submitted all the particulars of my school before the authority concerned, my lord, before the concerned director, my lord, since a hearing was conducted from the office of the director, my lord. As such, my lord, the DIAS code was not issued thereafter to me. In this regard, my lord, the district officer has made by himself a request to the concerned director, my lord, the mission director of Sarva Shiksha, to issue a fresh DIAS code either or for the renewal of the earlier DIAS code, my lord. But till date, my lord, they have not issued any, my lord, DIAS code as regards my earlier dias code pertaining to the year 2009 and 10. Although I fulfill the necessary criteria, which is mandatory, the dias code pertaining to the year 2009-10 is a mandatory criteria, the provincialization of service of the teachers. This is admitted by the authorities. And regarding the point number 2, my lord, whether the incumbents appear in the dias code of 2011 and afterwards, my lord, I could not submit because the particulars are in the office and custody of the concerned director. And in this regard, the district officer has made himself a request to the concerned director for issuance of a new dias code either or renewal of the earlier dias code, my lord. And regarding number C, my lord, the third point, my lord, the last point, enrollment position of the school during 2016 and 17, my lord. I, in this regard, my lord, want to my lordship's attention to my lord, page 84, my lord, annexure 18, my lord. What should we find? Is there an inspection report, my lord, which was issued on May 2017 by the SI of schools, my lord, concerned circle, my lord. Page 84, annexure 18, my lord. Pertaining to the year 2017, my lord, the number of students, my lord, right from class 1 to class 5, my lord, if we count, my lord, the number of students, my lord, it seems, my lord, 160, my lord. A fair number of students are there, my lord, in my school. As such, my lord, the impugn order, my lord, passed by the director and the decision taken by the state level scrutiny committee is not maintainable in the eye of law, and accordingly, my lord, this is liable to be dismissed. And my post, my lord, should be provincialized, and a direction may kindly be issued to the concerned authorities, my lord, to provincialize the service of the petition along with the other teaching staff of the school, my lord. That is my humble submission before your lordship.
Before going to all aspect, my lord, kindly peruse the order dated 7/11/2023 passed by this honorable High Court, my lord. So everything will clear, my lord. If I'm going to know. Honorable Court directed to
Page number, order dated
7/11/2023 passed by this honorable High Court, my lord. The honorable High Court directed to conduct press inquiry, my lord. Accordingly, inquiry was conducted, my lord. And
yes.
This is the inquiry report, my lord.
Where is the photographs?
Photographs not received. I have received these two documents, my lord. If lordship allow me to, then
No, the photographs are part of the report,
my lord. But so WhatsApp, my lord, I received this impact from my lord. So lordship, if required, my lord, then I will produce, my lord. Let the matter come after vacation, my lord. This will come. Student, I believe. Next one, submission. First one, elementary.
whether 28/1/2024 was a working day or holiday.
In this regard, but I want to submit one thing, one line before
Mm.
Lordship.
Mm.
The day when the inspection had taken place.
Working day, madam, Saturday.
The day when the inspection had taken place.
Mm.
Although that was a working day, my lord, but that was supposed to be a half holiday, my lord, half day, my lord. After some time, the school was, my lord, declared, my lord, as all the students had left along with the teachers, and the headmaster of the school, one of his close relative, my lord, he had succumbed, and accordingly he could not attend the school, my lord, in that particular day. I have a, my lord, specific instruction from the petitioner.
No, that's all right. He was absent, but the other teachers?
The teacher may remain present. my lord.
Pardon?
I don't have the instruction regarding other teachers, but they may remain present. my lord.
Have you seen this report?
No, my lord, I have no information.
Furnish a copy to him.
Madam,
Then you produce the photographs.
madam.
Heard Mr. Z. Ahmad, learned counsel for the petitioner, and Mr. Learned counsel for the standing counsel for the respondent number
Respondent number, limited education standing 1 and 2.
1 and 2, and Mr.
H for one, my lord, for respondent number 3 and 5.
Respondent number
3 and 5. As is
3 and 5, and Madam respondent number 4. 4. Mr. Talukdar, learned counsel for the learned standing counsel for respondent number 7, so has submitted a report before this court. Person to order of this court dated
27/11.
7/11/2023. 2023. It appears from the report that some photographs were also submitted along with the report, but the said photographs were not placed on record by Mr. Talukdar today, and he prays to produce the aforesaid photographs before this court, where is accordingly allowed. Recessal list the matter immediately after reopening of the vacation. The report furnished by Mr. Talukdar shall be part of the record.
Lord, a copy may kindly be furnished to me.
And a copy of the report be furnished to Mr. Hamad, learned counsel for the petitioner for it.
Lordship.
Item number 8. Lordship, I pray for some more time, your lordship, for our affidavit to be filed, your lordship.
Mm. Madam, on 11/9, you have submitted that you have received the instruction.
Yes, lordship, I have received the instructions, your lordship.
Then why you could not prepare the affidavit?
Just some more weeks, your lordship.
Hmm?
1 week more time, your lordship. 1 or 2 weeks more time may be granted, your lordship.
All right, we will grant you time, but you pay the cost. The routine manner we will not grant the adjournment.
There's a last chance, your lordship.
Hmm?
Last chance, your lordship.
Mr. Moya?
My lord, a man is without salary from 1999, my lord. Still working, my lord.
You filed the affidavit by 3rd of October. Heard Mr. Air Bhuya, learned counsel for the petitioner, and Terampi, learned counsel for the learned standing counsel for the respondent number.
All respondents are not.
For all the respondents. Ms. Terampi submits that she may be granted further 2 weeks time to file the affidavit in opposition. But it appears 11/9/2024, it appears that already 2 weeks time granted to her to file the affidavit in opposition, but she has failed to file the affidavit without assigning any reason. under the aforesaid facts and circumstances, this court is inclined to grant her time till 3rd of October, and in the event of failing to file affidavit in opposition on that day, the court will proceed to hear and dispose of the matter on the basis of materials available on the record without the affidavit of the respondents. 3rd of October.
Number 9.
In this case, my lord, I am sorry, my lord, in the last occasion, Mr. P.N. Sharma received the instruction, and today he, into some difficulties, he could not come, my lord. He informed me that he has prepared the affidavit, my lord. So let the matter come immediately after vacation. In the meantime, little more automatic.
My lord, after vacation, any date, my lord.
Okay.
On 25th October.
Heard Mr. N. Hock, learned counsel for the petition. Mr. Talukdar, learned standing counsel for the
Elementary
respondents,
education.
appearing on behalf of Mr. P.N. Sharma, learned counsel for the respondents. Mr. Talukdar, on instruction, submits that affidavit is being prepared and prayed for listing the matter immediately after reopening of the vacation. Here is accordingly allowed. Rest shall list the matter immediately after reopening of the vacation.
On 25th October.
25th.
Obligation.
Item 11.
Made previously. Well, this first appeal is under Order 43, Rule 1R, against grant of an ad interim injunction. The respondent as plaintiff, my lord, filed a suit for declaration of right title interest and confirmation of possession and injunction. The interim order, my lord, will find at page number 30 and etc.
The injunction order was ex-parte injunction.
Ex-parte injunction, my lord. January 2024. The next date has been fixed on 24/10/2024, almost after 2 months, my lord. In clear violation of Order 39, Rule 3A, where it specifically states that, my lord, an application for injunction has to be disposed of within 30 days. If I may.
Yes, all right.
And secondly, my lord, while granting the order of injunction, my lord, all the 3 cardinal principles, golden principles of granting injunction, my lord, prima facie case, balance of conveyance, that has not been discussed. Only
What is the MP on order?
at page number 30, my lord.
Page number?
30. Relevant portion is at page 31, my lord. Last portion. Third, learned counsel for the petitioners, produce materials on record. This is a suit for right title in interest and possession of the petitioners over the suit land and for permanent injunction. The petitioner submitted documents such as sale deed, sitha, jamabandi, revenue receipts in support of their contention. From the pleadings and materials on record, it seemed that the suit land was purchased by the father, husband of the petitioner upon whom Ravi Ram Rongpi, alias Mikir, by registered sale deed, and after death of the father, husband of the petitioners, the name of the petitioners have been mutated in the records of right as legal heirs of late Bhadoram Bosumutai. Petitioners ever to be in possession of the suit land since 45 years and has alleged that the OP is attempting to dispose them from the suit land without any right title interest. It is also seen that the name of the OP mutated in respect of.
Okay.
Secondly, last line, as per petition, OP is trying to dispose them under such circumstances, both parties are directed to make the status quo. So there is no finding as to regards, my lord, prima facie case, what balance of convenience would lie on which party, whether the plaintiff is going to suffer any irreparable losses or injuries if the injunction is not granted. And most interestingly, my lord, if my lord comes to the prayer portion of the plaint, my lord, there is no prayer for permanent injunction. My lord. At page number, my lord, will find at page 20. The prayer for permanent injunction is very vague. Page 20, my second prayer, permanent injunction, restraining the defendants or man, agents, etc. So nothing is there, my lord. In spite of being situated thus, my lord, learned court has granted ad interim injunction, my lord, fixing the date after 2 months. And because of the said order of injunction, now I am not able to get into my own land, my lord. That is covered by 487. So my respectful submission is that, my lord, this order should be set aside. I will appear on 24th of October, my lord, and I will file my written objection. Then, my lord, the matter will be disposed of as per law, my lord, on merits. Otherwise, my lord, if this order is allowed to be operated, my lord, I'm not able to go inside my own land, my lord. In this regard, my lord, I have got certain judgments also. If
No, not necessary.
Order 39, rule 3 is quite clear, my lord, that it has to be fixed within 30 days. Secondly, my lord, without a prayer for permanent injunction, no ad interim injunction can be granted. And thirdly, my lord, there is no discussion about all the three cardinal principles of law for grant of injunction.
Heard Mr. Iqbal, learned counsel for the appellant. This appeal under order 43, rule 1R, read with section 151 of the Code of Civil Procedure, is directed against the order dated 31/8/2024 passed by the learned civil judge senior division number 2, Kamrup M. Guwahati in Mise case number 798 of 2024 arising out of title suit number 450 of 2024. It is to be noted here that by the impugn order dated so and so, the learned trial court has granted has directed the parties to maintain status quo over the suit line as on that day, that is 31/8/2024. Mr. Iqbal, learned counsel for the appellant, submits that the respondent herein had instituted one title suit being title suit number 450 of 2024 before the learned trial court for declaration and permanent injunction, declaration of right, title and interest, and permanent injunction. Where is the pair portion of the
Page 20.
declaration of right, title, interest, and position of the plaintiffs stroke respondents in the respective suit line described in the schedule, and for permanent injunction restraining the defendants or men and agents. Men and agents. And in the said title suit, the respondents have also filed one petition under Order 39 Rule 2 of the CPC for granting ad interim injunction. And in the said petition, the learned trial court, by its impugn order dated so and so, has directed the parties to maintain status quo by waiving the notice under Order 39 Rule 3 CPC, considering the urgent nature of the case, and thereafter fix the case on 24/10/2024 after almost 60 days of passing the impugn order. Whereas there is a specific provision that the injunction application has to be disposed of within a period of 30 days. 30 days. Mr. Iqbal further submits that while directing the parties to maintain a status quo over the suit line, the learned trial court has not discussed the three golden principles of granting ad interim injunction. And what is the third point?
Third point is, my lord, that without a prayer for permanent injunction, my lord.
Yes, further submits that the prayer for injunction made in the plaint is vague. And without a prayer for permanent injunction, the learned trial court had granted the temporary injunction, interim injunction. And on such count, the impugn order passed by the learned trial court is arbitrary and illegal, and therefore it is contended to set it aside and remand the matter to the learned trial court, wherein the appellant will enter appearance and file his objection to the petition for injunction. Having heard the submission of Mr. Iqbal, learned counsel for the petitioner, counsel for the appellant, I have carefully gone through the petition and the documents placed on record, and also perused the impugn order dated 31/8/2024 passed by the learned trial court. And it appears that while the ad interim injunction was granted on 31/8/2024, the learned trial court has fixed the matter on 24/10/2024 after more than 60 days, which is in contravention to the provision of
Order 39, Rule 3A.
Order 39, Rule 3A, CPC. Further, it appears that the pair of permanent injunction is
H21
made in the plaint, which is enclosed with this petition at page number 20, appears to be vague. And on such count also, the impugn order appears to be arbitrary and illegal. And further, it appears that the learned trial court, bottom to keep over. No, episode of it appears. Okay. Further, it appears that in the impugn order dated 31/8/2024, the learned trial court had not discussed the prima facie case, the balance of convenience, and the issue of irreparable loss. And on such count also, the impugn order fails to withstand the legal scrutiny. And therefore, this court is inclined to allow this appeal in this motion itself by setting aside the impugn order dated 31/8/2024, and the matter is remanded to the learned trial court to hear the appellant and to dispose of the injunction petition within a period of 15 days.
15 days after 24th, madam. 24th is the next day.
Yes.
So,
Within a period of 15 days from 24/10/2024 in terms of this FAO stands to disposal of this.
Deeply obliged.
In view of order passed in FAO number so and so, the IA stands closed.
Item 12.
Page number 33 was the order, where a prayer was made for sending a document to the forensic expert, and that was rejected.
Page number?
Page number, that is 33. On the ground that, the person was not alive. The suit was for.
Yes, on the other day, perhaps we have heard the matter.
Yes, my lord.
The original document is not available.
Oh, our document is to us available, my lord. Originally available.
But the same is not legible.
They have disputed, no, my lord, they have disputed our documents, and we have disputed that their document is false. So a prayer was made to their document is Exhibit 8, the Kabin Nama. The plaintiff claimed that he is the son of my father, and claimed title suit for the partition of the title interest of the, my lord, property of my father, my lord. And we have disputed that his mother was not the wife of my father, my lord. And to prove the relation, my lord, he produced a Kabin Nama, marriage document. And that is, my lord, we have disputed that it is not the signature of our father, my lord. The father is no more, he has died. And this honorable court, my lord, page number 34, the finding is that page number 34, second paragraph, my lord. Our exhibit is Exhibit B, and their exhibit is Exhibit 8, my lord. The learned counsel for the plaintiff, on the other hand, has objected to the prayer made by the defendant, and he has stated that both the documents are different, and in absence of present signature of the person who alive to put signature, comparison cannot be made. No fruitful result came out, therefore has prayed for rejecting the prayer. I have gone through the exhibits submitted by both the parties, and it is already seen that the person who is named by plaintiff and defendant to be their father is already dead. Therefore, in this situation, comparison which be of no use here in this intent case, because the person whose signature is controversy is not alive to put his genuine signature for the sending the ex-parte. So, my lord, I mean, the other day, I think I have submitted my lord, citation of this honorable court, my lord, where it is mentioned that the person is dead or alive can be, my lord, take recourse of section 45 of the Evidence Act, my lord, for sending the document to the forensic expert, my lord. Paragraph 11, my lord.
The citation is on the other day you have taken it back from the court. It is not available with the record.
Have a copy, but March 13. Have marked it. Paragraph 11, my lord.
Yes. Yes, Mr. Bormian.
My lord, this judgment is not applicable in our case, my lord. My lord, this, my lord, theory of, my lord, expert opinion is that, my lord, for comparing all these things, my lord, expert must be, my lord, sure about one side, my lord, that this handwriting is from that person, my lord. Then he will, my lord, compare the disputed document, my lord. But here in this case, my lord, there is no occasion before the expert that, my lord, any document before him is, my lord, undisputed, or this expert is himself is sure that this signature is taken by that particular person, and disputed document is compared with that person, my lord. Here in this case, my lord, lordship, I have submitted affidavit giving chronologically, my lord, all the documents in my affidavit in opposition. Lordship, kindly have a look this document. Otherwise, my lord, he cannot hold, my lord, because original, because, my lord, page 45 in my affidavit, my lord, this is a, my lord, form. Generally, we submit before the BLO, my lord, to register our name or transfer our boot, my lord, from one place to another, or new booters name to be recorded, my lord. How he can, my lord, hold of this document, my lord, original document, my lord. It is, if it is at all, my lord, it is genuine document, that should be, my lord, in the office, and he can take this only certified copy, my lord. But this, my lord, document also, my lord, brought to the, my lord, mouth of the, my lord, witness who produced that, my lord, and I have annexed, my lord, R cross, my lord. Lordship, kindly look page 46. Page 45 is, my lord, the running page is this document. We are disputing, my lord, the authenticity of this document, my lord. And at her, my lord, cross, she, my lord, page 50, 11 portion, my lord. Page 50, my lord. B, exhibit B, my lord, in the middle, my lord. Exhibit B does not bear any seal, signature of any office, and it is not a certified copy. I gone through the plaint of the plaintiff, in the plaintiff, sister of their legal heirs also party to the suit. The plaintiff filed this suit for partition of inherited property of Sofikur Rahman, my father, my lord. And, my lord, entire village, 100% people know, my lord, then they are brother, my lord. When, my lord, good relation is also there, when he only just sought, my lord, that I am now, my lord, older, I want to come to my own village, give some plot of land to construct permanent house. Then, my lord, dispute started, my lord. Otherwise, my lord, they are, my lord, in good touch, my lord, so long, my lord, they are matured person, my lord. And this document,
let it be examined by the expert.
my lord, that cannot be, because, my lord, this is not the, my lord, undisputed document, my lord, and this is not the original, my lord, and he cannot, my lord, this is a fake document, my lord. And he, how, my lord, lordship, kindly consider how he can, my lord, hold this document, my lord. This is a form, my lord, to be submitted before the.
No, their signatures of the persons are there.
This is not the, my lord, signature of the father, my lord, my father, my lord. This is, my lord, this form is submitted to the office, my lord, for recording boots, my lord. That cannot, my lord, he cannot hold this original. If it is hold original, my lord, how it is possible, my lord?
This is not a form, my lord. It is
a form, my lord.
No, this court is not supposed to examine how he got this document.
Yes, my lord. Because, my lord, we are not supporting his document. He is not supporting our document. How, my lord, these two documents will be compared, my lord? Who has signature? For, my lord, expert opinion, my lord, expert should be sure about one document, my lord. Then he should compare, my lord, that yes, this document is from this person and this document is also written or not written by this person, my lord. Therefore, my lord, this impugn order, my lord, rightly passed by the learned trial court, my lord.
My lord, it is an electoral roll, my lord, not a form, as my friend submitted.
Kindly see the contents of
my page number 29 of my petition, my lord. It is, my lord, corrected, my lord, the electoral roll, my lord.
For correcting.
সংশোধিত নির্বাচন পত্র, my lord.
Yes.
It is provided by the, my lord, this BLO, it is called Goranakari, my lord. The BLO provided, my lord.
And who is this PLO, my lord? Nobody knows, my lord.
The learned trial court may not send the originals, my lord. We will submit the original, my lord. That may be forwarded to the, my lord, the forensic expert, my lord.
All, my lord, relative, my lord, supported my case. Is our
Mr. Bormuya, the issue before this court is whether to send the signature of the document containing the signature of the person concerned to the expert or not.
Yes.
So we are not on the merit of the case. Merit of the case will be decided by the learned trial court, not by this court.
But my lord, as per my lord, like Dividends Act, my lord, that kind of my lord, comparison is not permissible. Because this situation, my lord, this my lord, expert will not find out the truth, my lord. With whose signature, my lord, he will compare, my lord.
Let the report come, report of expert come. Thereafter, the trial court will consider the same. Now let it go to the expert.
No, we are, my lord, not supporting his document.
All right, you are not supporting, that's all right. But you will get the opportunity to dispute the same, dispute the report, and also dispute the cross-examine the witness concerned before the trial court.
My lord, in this case, my lord, the evidence herself, my lord, admitted this is not the authentic, my lord, document signed by the any officer, my lord.
Where?
My lord, page. This is my lord, page 46. This is my lord, DW4, my lord. It is translated part, my lord. In her cross-examination, my lord, I may be kindly allowed to read out page 49, my lord. Cross. Ayub Ali Lashkar is my grandfather. Ayub Ali had two sons, namely Abdul Bari and Shafiqur Rahman. I cannot say the name of the legal heirs of Shafiqur Rahman and the present plaintiff and defendant. My side is plaintiff, my lord, and his side is defendant. I cannot say total quantum of landed property of Shafiqur Rahman. Then I also cannot tell the quantum of landed property of Shafiqur Rahman, and I also cannot say the Dak Patta of the Shafiqur, property of the Shafiqur Rahman. My grandfathers had 5 brothers, but I cannot say their name. My father died in the year 1989, but I cannot say whether death certificate of my father was substituted in this court or not. I have not inquired about the documents which submitted or exhibited by the plaintiff. My father was resident of Lokibon Part 1. In Exhibit 5 Bhutan list, the name of Ayatul Nesa is appeared in serial number 73 of holding number 23 in the year 1966. I do not know Sharafuddin. This is my lord, my side, Sharafuddin, but it is appears in the Bhutan list of 1997 of Batit Sangjurai, name of one Sharafuddin, son of Shafiqur Rahman. By serial number 434, holding number 126, who filed the instant suit. I cannot say. It is not a fact that I know Shafiquddin, who is my stepbrother, and knowing the fact, I am denying the fact with intention to deprive him to landed property which inherited from his father Shafiqur Rahman. It is not a fact Sharafuddin is the son of Shafiqur Rahman through his wife Ayatul Nesa, and it is well proved by supporting documents. I cannot say my date of birth. Myself or my brother did not file any counter claim against the case of plaintiff in support of written statement. It is not a fact that my father married Ayatul Nesa in 22nd July 1959 by executing a Kabinnama. I do not know prior to marriage of my mother with my father, she had a marriage with a man who is a resident of Bawargat. It is not a fact that my mother was married with a person of Bawargat prior to marriage with my father, and I conceal the same. This is important. Exhibit B. which they are, my lord, relying, does not bear any seal, signature of any office, and it is not a certified copy. And now, my lordship, kindly will look this plaintiff's mother and father together in the voter list of 1966, my lord. Page 57, my lord. I have an.
On merit, my lord, my lord.
57, my lord.
Trial court will go to the merit.
66.
This is a simple petition for forensics.
Dear my lord, Ayatul Nesa, my lord, Shafiqur Rahman and his father, name, my lord, Ayatul Nesa, this mother of my lord, my side, my lord, and father, my lord, Shafiqur Rahman, Lashkar, my lord. This is, my lord, 1966, my lord. And thereafter, my lord, 1970, my lord, page 59.
So this exhibit B is of which year?
89.
89, my lord. And he 89, he died, my lord, my lord.
One 489.
All the, my lord, evidence, my lord, so far, my lord, given before the court below, my lord, supporting that they are brothers. And lordship, page 59, my lord, this is a voter list of my lord, father and mother, my lord, 1970, my lord. Ayatul Nesa, Shafiqur Rahman. Then, my
Mr.
lord,
Kader, you see this in view of the admission in this para number, page number 50. How this document can be relied
My lord,
upon?
the trial court, if the my lord plaintiff petitioner here is submit the original, my lord, only original can be forwarded, my lord. So, my lord, the original to be forwarded, that must be directed, my lord.
fake
The
document,
original
my lord,
document, my lord.
only dilatory
The
check is,
petitioner
my
will
lord,
submit, my lord.
wrong document, my lord, old document, name, my lord,
Okay.
died, my lord, in the same year, my lord.
We'll hear you after 2 p.m.
My lord. Obligement. Application, my lord, page 35.
So, first, let us see the ground of rejection of the petition by the trial court.
Yes. My lord, page.
Order dated 3/11.
Yes, my lord. It is starting from page 33 and 34. Relevant portion, my lord, page 33, last line, my lord. The defendants have denied the exhibit A and they claim it to be forged document where the signature is not made by the defendant's father. Defendants, along with the evidence of DW4 exhibited document by exhibit B, where the father of the defendant number 1 put his signature, which is valid and genuine signature of the father of the defendant. Therefore, it has been prayed to send the both exhibit 8 and exhibit B to the handwriting expert for examination and opinion as to which one of the genuine signature of father of the defendant number 1. The learned counsel for the plaintiff, on the other hand, has objected to the prayer made by the defendant, and he has stated that both the documents are different, and in the absence of the present signature of the person who allied to put the signature, comparison cannot be made and no fruitful result is came out. Therefore, he has prayed for rejecting the prayer of the defendant. I have granted through the exhibit submitted by both the parties, and it is already seen that the person who is named by plaintiff and the defendant number 1 to be their father is already dead. Therefore, in this situation, comparison which be of no use here in this instant case, because the person whose signature is in controversy is not allowed to put his genuine signature. Expert. Lordship, now my lord, assuming is given to expert, according if their prayer is, my lord, allowed, what my lord expert will say? He will just say this is not matching with that and that is not matching with that. Then situation is the same, my lord. Therefore, my lord, learned trial court rightly held that, my lord, to get the benefit of the ex-parte, my lord, present signature of the person is necessary. And my lord, the Indian Evidence Act is also like that, my lord. Page, my lord, 45 of the Evidence Act, my lord. 45 is just, my lord, opinion ex-parte, my lord, is necessary like that, my lord. When the court has to form an opinion upon a point of foreign law or of science or arts or as to identity of the handwriting or finger.
No, Mr. Borboya, have you gone through this judgment of this High Court?
Yes, my lord. This is, my
Jayanti
lord,
Gogoi and others versus Pranoti Dwara and others.
yes, my lord.
Paragraph 11. Lord, may I read? I have a copy, my lord.
Kindly, I may be allowed to complete. Therefore, my lord, in this case, my lord, in our, my lord, facts and figure, my lord, here, my lord, even it is given to ex-parte, my lord. Ex-parte at best, my lord, can say this document is not matching with that document and that document is not matching with that document, my lord.
No, that is your presumption only.
Only, my lord, because there is no admitted document. Because specific, my lord, suppose one document I have exhibited, that document they are admitting. Or they have, my lord, submitted any exhibit, my lord, which is we are admitting. Only then, my lord, if expert said that yes, this is matching or not matching, that may, my lord, court may use this opinion. Here in this case, my lord, they themselves and we.
No, but have you gone through this judgment?
Yes, my lord. Paragraph, my lord, 11, my friend is referring, my lord. May I read, my lord?
No, not necessary, but what is your submission on
My
this?
lord, my submission is that, my lord, here it is not, my lord, matching with our case, my lord. And this is different, my lord, regarding.
No, facts may be different, but the law laid down therein.
Yes, my lord.
Can it be applied in our case now?
No, my lord, because here, my lord, admitted document is not there, my lord. And my lord, the document, my lord, DW4 herself is, my lord, stating that, my lord, this is not the, my lord, certified document or authentic document, my lord. In her.
But that is a document containing the signature of her father.
No, my lord, it is not her father, my lord. It is
No,
wrong document, my lord. Therefore, my lord, we disputed, my lord, and my lord, it is brought, my lord, in the cross, my lord. And my lord, any document, my lord, which we are admitting, my lord, if they wanted to compare, my lord, this is altogether different, my lord. Here, my lord, both the document we are, my lord, disputing each other, my lord. Therefore, my lord, expert opinion will be compared with which document, my lord. There is no, my lord, undisputed. But, my lord, so far expert is concerned, my lord, expert should be sure and certain regarding one side, my lord. Then he will compare, my lord, yes, this document is matching or not matching, my lord. Therefore, my lord, there.
Okay, okay, we reserve the order. Third, Mr. Borboya, learned counsel for the respondent, argument concluded, order reserved.
Coming item number 5 for motion. Item 5.
May I please, lordships? My lord, this case has been filed, my lord, challenging the order, my lord, 6/6/2024. That is at page, page, my lord, 23, my lord, that order, my lord. In this case, my lord, on 6/6/2024, my lord, the case was fixed for judgment, my lord. The earlier, I have annexed all the documents, my lord. That case has been fixed for DW on several occasions, my lord. And thereafter, argument has been heard by both the parties, my lord. And thereafter, my lord, ultimately, my lord, on 6/6/2024, my lord, case has been fixed for delivery judgment, my lord. But on that day, my lord, very surprisingly, my lord, the insurance company has filed, my lord, that the respondent, my lord, has filed a petition, my lord, for adducing DW, my lord. And on that very day, my lord, without hearing the, my lord, claimant side, my lord, that's the petitioners, the learned tribunal has passed this order, my lord, without any hearing, my lord. That is reflected in the order itself, my lord. May I read, my lord? Today is the date fixed for judgment. Learned counsel for the OP number 1, that is the insurance company respondent hearing, has filed a petition number so and so, praying that due to important information regarding DL concerned of the driver of the offending vehicle, examination of the DTO Mon Nagaland is required. Since the petition heard the learned counsel, in order to advance the cause of justice, instead of delivering the judgment, the OP is allowed to adduce defense evidence. Without our hearing, my lord, this order has been passed, my lord.
Okay, we set aside the order. You
Yes.
go and file objection there.
Obliged, my lord.
Heard, Mr.
Yes, Ahmed.
Yes, Ahmed, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, read Section 115 of the CPC, the petitioner, 4 petitioners, namely so and so, so and so, so and so, has put to challenge the correctness or otherwise of the impugned order dated 6/6/2024, passed by the learned member MSCT number 3, Kamrup M. Guwahati, in MSC case number 1537 of 2017. It's to be noted here that by the impugned order dated so and so, the learned member MSCT number 3, Kamrup Guwahati, has allowed the petition number 1160 of 2024 passed by the filed by the respondent insurance company, National Insurance Company Limited, for adjournment and to allow it to summon under Order 16 Rule 14 of the CPC the DTO Jorhat, Assam and DTO Nagaland to verify the permit. And fix the case for evidence of the defendants as license. Which one is the impugned order?
My lord, impugned order page 23, my lord, last page, my lord.
6/6/2024.
Yes, my lord.
Okay, so that petition number is different. 3832. Allowed the insurance company to adduce a defense evidence while the case was fixed for delivery of judgment. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioners are aggrieved by the aforesaid order on the ground that the said order was passed without affording any opportunity of being heard to the petitioners. Mr. Ahmed further submits that the case was on that day fixed for judgment, delivery of judgment. after affording after affording opportunities to the defendants to examine their witnesses. And since the order has been passed without hearing the petitioners, Mr. Ahmed submits that the order may be set aside and quashed, and the petitioners may be allowed to file an objection to the petition number 38/2023. No, 38/23 of 2024.
Pardon, my lord.
Hmm.
Pardon, my lord.
Yes.
I say, I will not file any objection. This order may be set aside, and thereafter, if the respondent, my lord, insurance company will file another petition, then
No, yeah, you file objection there. Your contention is that this order was passed without hearing you.
yes, my lord.
Hmm.
My lord, this order may be set aside, and
Why?
subsequent, my lord. Thereafter, my lord, if they will file, my lord. Otherwise, on that petition, my lord,
No,
on the basis of
this order is arbitrary on the ground that it was passed without hearing you.
my lord.
Hmm?
Well, if they will file another petition, then I will.
No.
My lord, then my lord. Yes.
But having heard the submission of learned counsel for the petitioner, I have carefully gone to the petition and the documents placed on record, and also perused the impugned order dated 6/6/2024, which is reproduced herein below for ready reference. It appears that the impugned order was passed without affording any opportunity of being heard to the petitioners. On that day, that is 6/6/2024, the case was fixed for delivery of judgment, but without delivering the judgment, the learned member MSCT, on the basis of the petition number 38/2023 of 2024 filed by the respondent insurance company, has allowed the insurance company to adduce defense evidence. In that view of the matter, the impugned order dated so and so failed to withstand the legal scrutiny, and accordingly the same stands set aside and quashed. The matter is remanded to the learned member MSCT number 3 Guwahati to afford an opportunity of being heard to the petitioners, to file objection, and also to file objection in respect of the petition number 3823 of 2024 filed by the petitioners. In terms of this CRP stands the disposal. When the next date is fixed?
My lord, just after 2 minutes, my lord, I'm giving, my lord. Most probably, my lord. 4th of October, most probably, my lord. I'm just confirming it, my lord. Just after 2 minutes, my lord.
Okay, you inform the court master.
Obliged. Much obliged, lordships.
Item number 13 for admission.
Please, your lordship. I am referring for respondent number 4. Lordship, kindly be pleased to provide us some time for filing affidavit,
My
as
lord.
the senior is unwell.
My lord, they have taken times on several occasions, my lord. Admitted fact is that private respondent number 4 is junior to me, my lord, and I am senior. Therefore, this honorable court has stayed the impugned order, allowing the inspector of schools concerned to hold the charge of the principal of the school, my lord. And I being the qualified, eligible senior most teacher of the school, my lord, I'm legally entitled to hold the charge of the principal of the school, my lord.
Madam, you are for respondent number 4.
Your lordship.
And the
4.
Yes, lord.
The issue.
This lordship.
And the issue of this, my lord, case is already covered by the judgment, my lord, page number 60. Similar judgment is there. Already, this sort of issue has been decided. In respect of another school, my lord.
That's all right. Let her file a objection. Affidavit in opposition.
For the last time, last opportunity. A date may be given immediately after vacation for final disposal.
Okay, heard, Mr. Your good name.
Be protested.
Learned counsel for the petitioner and Madam
SS again.
SS Soikia, learned counsel for the respondent number 4. And for rest of the Mr. Khatonia for respondent number 1, 2, and 3. 1, 2, and 3. Ms. Soikia submits that she may be granted time to file affidavit in opposition. Here is allowed to recess the matter on
20th October.
so as to enable Ms. Soikia to file affidavit in opposition. Interim order
Is already suspended, very impugn is suspended.
suspended.
Okay. And follow-up compliance order has been issued by the director, allowing the inspectors to hold the charge.
Item 14.
PG Lordship. It relates to my lord revising of grade pay of rupees 8,700 Lordship, which they were getting Lordship. They are employee of the SCRT Lordship. Lordship. In this case, Lordship, yesterday I have filed one affidavit in opposition, Lordship. And in my affidavit in opposition, I have stated that now matter is before the finance department, Lordship. We have clarifications, some clarification from the finance department, Lordship. So finance department affidavit is also required, Lordship, in this case.
Here, if I can get a copy of the affidavit which they have filed, Lordship, I can put it up with the department and get the necessary instructions, because Lordship, they have our affidavit, we'll file an affidavit if required, Lordship, but some clarifications were sought. So if we have addressed those clarifications, I think our affidavit will not be required also, Lordship. So
Lordship, I'll
some time may be granted so that I can.
My lord, I am for the petitioner, my lord. My lord, in fact, the stand of the finance to be reflected by made as an affidavit. Why I am stating, my lord, because the petitioner here in our stenographer's grade 3, via 2017 notification, our grade pay was enhanced from 7,400 to 8,700. Thereafter, and that notification was issued by the finance department. But subsequently, in the year 2024, via another notification issued by the finance department, by the AG, Office of the Accountant General, our grade pay was reduced. Thereafter, we filed this writ petition. And in the writ petition, my lord, the Accountant General, Office of the Accountant General filed affidavit in opposition. And in that affidavit in opposition, they have clearly stated that the stand of the finance department would be necessary. If they make their stand clear by way of an affidavit, it will be easier for us. Because ultimately, the lordship have to adjudicate the matters.
Finance department is the issuing authority. The executing authority will be the parent department. In this case, it will be the officials in the SF. But Lordship, we'll file an affidavit.
Yes, that will be the Lordship.
But in the affidavit that has been filed by the AG Lordship, only some clarifications have been sought. It's not like we are the ones who are. So on the basis of that additional affidavit, we'll put our response. Lordship.
Okay. Heard, Mr.
K. Mohammed.
K.
Mohammed.
Learned counsel for the petitioner and Mr.
RK Talukdar, Lordship, for respondent number 4, my lord.
RK Talukdar for the respondent number 4 and Mr.
A Solia for respondent number 2
A Solia for respondent number
2 and 3.
Respondent number 2 and 3 and Madam. Pardon? Respondent number 5. Mr. Talukdar, learned counsel for the respondent number 7 submits that he has filed his affidavit in opposition yesterday.
Yes, Lordship.
Yesterday. Mr. Soliha, learned counsel for the respondent number 7 submits that he will file affidavit in opposition here in this case, and he prays for granting him some more time, where is accordingly allowed. Shall list the matter immediately after reopening of the petition.
3 weeks, not immediately, Lordship, after 3 weeks, maybe granted.
6 weeks after reopening, it will over.
Yes.
3 weeks.
Item number 15.
May I be watching? Here the petitioner is the, my lord, senior-most teacher and holding the charge of the headmaster of the high school, my lord, for since 2019. And my lord, he has neither been considered for promotion nor, my lord, he has been given any charge allowance, etc. without any financial benefit, my lord. He is continuing in the in-charge headmaster of the school, my lord. He has submitted, my lord, one representation in that regard, my lord, for expediting the process of promotion to the post of headmaster, and to include his candidature for the same. Representation Act number 23. 23. Mission is that, my lord, this will be disposed of with a direction to the authorities, my lord, to take into his take into consideration his candidature. For the purpose of promotion.
Yes, Mr. Khatania.
Yes, Malab, in fact, in case of Jorhat district, it is under process, Malab. The selection list is under consideration of the state selection board, Malab. Malab may direct the respondents to consider his representation because it's in the final stage. The process of selection of headmaster is in final stage, Malab.
Heard, Mr.
Be prepared.
Learned counsel for the petitioner and Mr. Khatonier, learned standing counsel for the
secondary education, Malab.
Secondary education. In this petition under Article 226 of the Constitution of India, the petitioner Sri Kusal Kumar Asoni has tried for issuing direction to the respondent authorities to complete the process of promotion to the post of headmaster. This has been initiated by the Directorate of Secondary Education, Assam, through the communication dated 1/6/2023, which is annexed with the petition as Annexure 5. Mr. Rukesto, learned counsel for the petitioner, submits that the petitioner has been working as in-charge headmaster of Malokhat High School. High school or higher secondary school?
High school, sir, my lord, and now designated, initially it was high school, now designated higher secondary school.
Malokhat High School, now designated as Higher Secondary School of Jorhat District. And he has not been provided with any financial benefit for holding the in-charge headmaster. And he has also not been promoted to the post of regular headmaster. And that he had filed on representation on page number
23, Madam. 27 July
on
2023.
27 July 2023, but the same failed to evoke any response from the respondent authorities. And therefore, a contention is being made that this writ petition may be disposed of by directing the respondent authorities to consider his candidature for the post of headmaster in terms of the representation dated 27 July 2023. Mr. Khatonier, learned counsel for the Directorate of Secondary Education, submits that the process for the Jorhat district has already been initiated by.
According to that communication, it has been initiated and it is under in the final stage, Madam.
already been
Before the
initiated,
state selection board, my lord. It is before the state selection board.
already been initiated by the state selection board. And the same has been communicated by annexer
No,
5
yes, my lord.
dated 1/6,
It is initiated by annexer dated 1.
which has already been initiated by annexer 5 dated 1/6/2023.
And it is now pending before the state selection board, my lord.
And the matter is now pending before the state selection board. And when it is expected to complete the process,
My lord, within a month or two, my lord.
and further submits that within a month or two, the entire process will be completed. And as such, this writ petition may be disposed of by directing the respondent authorities to consider the candidature of the present petitioner. Having heard the submission of learned advocates about the parties, and also considering the facts and circumstances on the record, this court is inclined to dispose of this writ petition by directing the respondent authorities, especially respondent number 2, to consider the candidature of the present petitioner in terms of his representation dated 27 July 2023. Within a period of, so we fix a timeline?
1 month, my lord.
2 months, my lord, because
Within a period of 2 months from the date of receipt of certified copy of order of this court. The learned, the petitioner shall obtain a order and place the same before the respondent number 2. In terms of this WBC instance, disposal.
Number 16.
May I please? In this case, my lord, the petitioners are the teachers of the high schools, my lord, and higher secondary schools. They are, my lord, qualified for advance increment, my lord. The condition, my lord, for getting one advance increment on account of B.Ed degree was that those teachers who have been appointed prior to 2012 and, my lord, have been serving in the high schools, my lord, they are entitled for one advance increment. Annexure 1A, my lord, is the.
in any case, my lord, here I am praying for some time to file my reply, my lord.
Huge numbers of cases have been disposed of, and I have given the NXP orders also, my lord. If they want to file their reply, I have nothing to say, but the urgency.
No, otherwise, Mr. Khatonia, otherwise they are entitled, though.
But there's some development. I have received some information from the department, so my lord will fix it after vacation. I will place it on record. Well, if it is covered, my lord may pass order. But still, since I have some instruction I have received from the department regarding some other cases, so I'm praying for some time so that I can, if required, I will bring it on record by when I type it.
Or Mr. Purkasto, learned counsel for the petitioner, and Mr. N.J. Khatonia, learned standing counsel for the secondary education Assam. And for rest of the respondent, Mr. Bhattacharya, state of Assam. Mr. Khatonia submits that he has received instruction and he will file an affidavit in opposition and press for granting him some time. Pair is accordingly allowed. Rest is shall list the matter immediately.
Well, better we come on, my lord, 30th October, my lord.
30th. Okay.
Okay.
Item 17.
May it please, Lord.
Yes.
Also, this is regarding admission in RINC, Rashtriya Indian Medical College at Dehradun. Lord, the admission of his petitioner is to be in the class 8. Lord, he has gone through an entrance examination, all India level entrance examination, my lord, and he has qualified. Now, before I go into, my lord, Lord, you may kindly turn to page 13 of my petition, that is annexure 1, my lord. This is the number of vacancies they show, and there are state-wise distribution in all over India. And the distribution of page 13, annexure 1 of the petition.
Yes.
Lord, at serial number 3, that is the vacancy for Assam, one vacancy.
altogether 36 seats down below, Lordship. Then all the states they are having only one seat, bearing 2 and 3, depending upon the population. Next page is the admit card issued. I appeared on 2nd of December. I qualified. Annexure 3 at page 15 is the call letter for appearing in the Viva Voce. I cleared Viva Voce also. Thereafter, my lord, the state and all India level merit list was prepared. Lordship at page 16. Annexure 4 is the state level merit list. 2 students from Assam was selected. I stood at serial number 2. Harshit Sandilla, the petitioner. So, Annexure 5 is the all India merit list. Lordship will find at page 19. And kindly turn to next page, page 20. Serial number 37 is my position. Altogether, 44 students were selected after Viva Voce for those 36 seats, and I stood at serial number 37. Thereafter, my lord, this medical examination was conducted. I was asked to appear. Lordship, may kindly turn to Annexure 7, page 22. This is the result. Para 2. My lord, in respect of Master Harshit Sandilla, son of so-and-so, herewith the triplicate along with the report and find necessary action. It is intimated for your information that above named candidate is found medically fit for admission in your school. My lord, I cleared the medical examination also, my lord. My lord, in one of the paragraphs of my petition, I said, though 44 students were selected all India basis and they were called for medical, only 34 students out of that 44 have cleared that medical. And this fact has been admitted by the RIMC authorities while filing their affidavit in opposition. My lord, in their affidavit in opposition at para 13, they admitted, Lordship, may kindly turn to page 28. That is their affidavit. I'll show the admission part that yes, only 34 have clarified.
Page number
28 of affidavit in opposition it is. Also got it. On the top, para 13, that para 12 of the writ petition is admitted. It is admitted that only 34 candidates cleared the medical test out of 44 candidates who qualified the written examination and Viva Voce examination and were eligible for admission to RIMC Dehradun. Against 36 seats, 44 was selected after Viva Voce examination. All 44 will call for medical. Only 34 has cleared medical examinations. My lord, this RIMC, my lord, Rashtriya Indian Medical College at Dehradun is a school, my lord. It is administered by Ministry of Defence, Union of India. And admission is given twice in a year, in the month of December and July. The petitioner applied for session July 2020, this year. And as my lord, Annexure 136 seats is to be given. I was not called for. Only 28 students were called for taking admission. The list of students they were called for I have given at page 8 of my writ petition, para 13. On 25th of July 2024, they have called 18 students. Thereafter, on 14th of August, at page 8 of my writ petition, para 13.
Yes.
In the first lot, they call for 18 students for admission. These are the names I have given. And thereafter, on 14th of August, they asked for taking admission another 10 students. Altogether, 28 students were called for. I was left. Hence, this writ petition was filed that I ought to have selected because as per Annexure 1, there were 36 seats. Now I stood at 34. That is an admitted fact.
But the seat allotted to Assam is only one.
Yes, my lord.
And then
yes,
in that seat, one student has already been selected.
Yes, selected and he took appointment, admission also. But my lord, that is why this All India merit list is prepared. Because there are other instances also. For example, from Haryana, they have taken 2 students. Though against Haryana, they are only reserved candidate. If, my lord, all the seats are not qualified, then they took up from the reserved candidate. I can show that. Examples are Haryana and other states are also there. In Rajasthan also, they have taken more than the distributed this allotted seats, they have taken more students. That is the procedure. If there are vacancies, they can take and they take it. Well, they have filed their written objection now, the affidavit in opposition now, and they say, no, this time only 28 seats are there because we have to find out by applying some procedure, and altogether in RIMC there are up to have been 250 students, so we can admit up to 28 students only. That is their stand in their affidavit in opposition. So come to that, and they also dispute by Annexure 1. Say this is a manipulated document. This is not the document. They have annexed one document. Lordship may kindly come, which I have disputed by filing my reply. Which may kindly turn to page number 32. Oh, sorry, not 32. Page number 38, Annexure 2. Page 38, Annexure 2 of the affidavit in opposition. Has your lordship got it?
Yes.
Well, down below there is a note. Number of seats may vary. Well, in Annexure 1 that I have shown in page 13, this note was not there. They say the seat may vary, and this time only 28 seats. Well, this I have objection, and I said, because everything was online, the document form, everything we have to download from their website. In my reply, I said they shared us a website. That website is I have mentioned in my affidavit in reply. And if I open it today also, that the same very list that I have enclosed as Annexure 1 will come. This note will not come in. So with all respect, my lord, I said this document was not there, and maybe this has been inserted later on, because I have filed my affidavit in reply, wherein I enclosed two documents, Annexure A and B. Therefrom, it can be seen that this document was uploaded in the website at a later point of time. So that
Whether the earlier document is there? No.
Yes, available in my, they have shared with me, and if I click that link, that earlier document will come in. My lord, I have mentioned, lordship may kindly come to my affidavit in reply at page 43. Because, my lord, I consider it is a serious allegation on me, my lord, because I have not given any wrong document. That is why I have given this. Page 43. On the top, my lord, this is the link they have shared to all the students. Actually, they floated it in their website. This is the link. If we click this link today also, my lord, the same very list will come in. And they have blocked this, but if I have shared it, because that link was saved in our mobile file, filling up the forms and all. So if I click on this, the same list as I enclosed in Annexure 1 will come in of the writ petition. Now, subsequently, wherever lordship may kindly turn to page number 46, Annexure A. Very interestingly, I have annexed those two documents. This is Rashtriya Indian Medical College admission procedure they have floated in their website. On the top, lordship will see that RIMC.government.in that address is there, and it was floated on. Here, lordship will get it. This position on the top. The date lordship can say after the worldwide 2023-12-07 means 7th of December 2023 it was floated. Lordship may kindly turn this, if we continue at page 47 this ends. This annexure ends at page 47 with withdrawal. Has your lordship got it? Now, lordship, kindly turn to annexure B. Next page, at page 48.
So why you have pointed out to
yes,
the
my lord, I'm coming to that, my lord. Lordship, same on the top, if your lordship sees RIMC government.in, this was floated on 2024-09-13. Means this was floated in the website on 13th of September 2024. Now, lordship, kindly turn to the next page. after withdrawal, they have annexed their list that they have now say the state-wise distribution. Has your lordship got it? This was not there earlier prior to that. 14th of September, this was not there in their website. Now it is there with the note also. Note lordship will find at page number 51.
Yes.
So this is the minimum because it is their website. They can manipulate, they can handle, they can operate it. They can block us also because it is their website and Ministry of Defense is involved. So lordship understand, my lord. There are, but this got saved in the web library. That is called web archive, my lord. They saved this movement in the websites all over different websites, and this is stored there that on such and such date to this date, this document was there, and thereafter this has been floated on 14th of September. And this affidavit in opposition, lordship is notes, my lord. This was filed on 12th of September 2024, wherein they, for the first time, they say that only 28 seats were there. And there is no document enclosed along with the affidavit filed by them. How come they have calculated this 28 seats? For the first time, we being the applicant, we have come to know that there is a procedure to find out. This annexure one was there till there. I have shared with my friend also, appearing advocate, who is appearing from the RIMC. He has also seen on my mobile as this annexure one document is there, and there were 36 seats. If there are 36 seats, then I being at 34. And my position now in the merit list after medical examination stands at 31. So I am entitled to. And there is another one aspect, my lord. Suppose we go by there are 28 seats. Suppose, my lord, as they have said so, because we have no other way to prove it because they are saying now. Now, I have explained that also, my lord, that I am entitled to. This fact they had suppressed in my humble, at page 41, my lord, of my affidavit in reply.
Page number 40?
41. This is the affidavit in reply, paragraph 3. Relevant portion will be page 41. May I read it? Second paragraph.
Yes.
That the deponent states that he has learned from reliable sources that although 28 students were called for taking admission, but some students did not took admission or left RIMC after taking admission, and therefore another 2 students, that is students up to serial number 31 of the merit list, were called for taking admissions. The deponent also come to know that at present altogether 28 boys students have been pursuing their course in the July 2024 session of RIMC. The deponent therefore humbly prays before this honorable court to direct the respondent authorities to produce the following documents. They have not enclosed. Number 1, the final merit list, because the merit list that I have shown state level and only that is prior to medical examination. So they may be directed, my lord. That is my prayer. That final merit list of students who have completed all 3 rounds of examination for admission in July 2024 session, and list of students who were called for taking admission in the July 24 session, and the list of students who are presently continuing with their course in July 2024 session. If, my lord, my final position in the merit list is 31, and 30 students have already been called for taking admissions. They have taken admission and 2 have left. Now there are only 28 students who are studying. So 1 seat still remain vacant out of those 28. And I should be called, my lord. I have stated in my affidavit, they have vindictively and they have taken it as a challenge, my lord. They are not calling me. This instruction, if they can produce, my lord, then probably I am getting a seat, my lord. This is a very tough qualified, tough entrance exam we have to go through, my lord, all over India. And last 3-4 years, there were no students from, and lordship can see from the list in the entire Northeast, only 2 students qualified from Assam. 1 got selected, and I stood at, in entire Northeast, including Sikkim, none of them. In last 3-4-5 years, no student from Assam got it. And these students, they occupy the highest level of military services after completion. This was established by British in those days, 100 years old school. This is in Dehradun. So, my lord, if I can get a seat, and procedure is that you are to get admitted from the year 11 years to 13 years. And this time I am completing 13 in December. I have stated in my affidavit petition. No scope for appearing in the next year. So, my lord, if there are vacancies, and I have stated they have admitted also in states like Haryana and Odisha, I think, my lord, in both these states, though there are only one seat allotted, more than one students are admitted because of the vacancies. They admit this position. If the seats are there, can be considered my position.
Yes.
So, the allegations which have been made, my lord, since it's a very prestigious institution, Rashtriya Indian Military Academy, my learned friend has tried to make allegation that he has been deprived.
No, forget about the allegation. Forget about the
correct, my lord.
allegation. If there is a one seat, then why he
My lord,
cannot be
at present, my lord,
accommodated there?
all the seats have been full. I have taken instruction. 28 seats were there, my lord. 28 seats admission have also been, students are studying now. And even the next batch has also, my lord, exams are notified for January 25. Next batch is also coming. My lord, my first contention is, my lord, regarding the note, my lord, that note which my learned friend is saying that we have manipulated it from the system, which is completely incorrect, my lord. Otherwise, then, my lord, there has to be evidence has to be laid. You know, technical experts have to be brought to, such an allegation should not be made unless, my lord, confirmed that the authorities in Rashtriya Military Academy
No, no.
actually manipulate the advertisement.
Regarding this page number 1.
My lord.
So it was downloaded from your website.
That is not correct, my lord. In fact, we have first disputed by saying that the document which they have annexed is to mislead the court. After we file the affidavit, my lord, this thing is coming up. Now, this will be a matter of evidence, my lord. As on date, my lord, this note is there in the website. My learned friend is saying that as on
No,
date.
maybe as on that, he also admitted that as on that it is available.
The allegation, my lord, which is making that we have modified it, my lord, how can it be proved unless, my lord, evidence is led to that effect? Such allegations, my lord, before the writ court, my lord, it has to be proved. And we as an authority, my lord, we are taking a categorical stand that there was a note, my lord, at page 38 of the affidavit, which the note says, my lord, that the number of seats may vary every year subject to the total authorized strength and approval of higher authority. So 36 vacancies was there, my lord, that is incorrect. And, my lord, in paragraph, my lord, 15, my lord, will take at page 28 explanation to the how the vacancies have arrived, my lord, that is also there. Page, my lord, 28, paragraph 15. How the vacancies are determined, that is also, my lord, we have categorically stated. So page 28, my lord, paragraph 15. If I may read, my lord. That the averments, my lord, made in paragraph 15 of the writ petition is not admitted and vehemently denied. It is denied that still 8 seats are vacant for the session commencing from July 24. It is denied that the authorities or the administration of RMSC has whimsically and arbitrarily decided to fill up only 28 seats and deprive the petitioner from his right to admission in July 2024 session of RMSC. It must be noted that Rashtriya Indian Military College is a Category A training establishment administered by the Ministry of Defence, Government of India through Army Training Command. Its primary objective is to train cadets for the admission to National Defence Academy, which is a similar category institution. Such cadets are selected on the basis of their performance in an all India entrance examination by following standard operating procedure for the selection of candidates. Clearing the written examination, viva voice and medical examination does not give the right or guarantees admission. The selection process just helps to determine and find out the best candidates for the vacant seats available for any academic session. Now, this is important. It is not necessary that every year there will be a 36 vacancy for admission into RMSC. The number of vacant seats is determined by a process followed by standard operating procedure. It is of paramount importance to bring this to knowledge that the vacant maximum total strength of the RIMC for students is 250 for every year, and the number of vacant seats for admission are determined by the fact that how many students have passed out or left from RIMC in a session. That is the reason, my lord, the vacancies have now varied from 36 to 28. The number of students passing out, leaving the institution determines that how many vacancies will be available for admission.
It is to be noted that in the present matter in question, there were only 28 vacancies available, and hence only 28 candidates were selected and admitted for the July session of the RIMC. Now, my lord, coming to the my lord, these select list, my lord, which the petitioners have announced in the petition. My lord, it is important to note that the petitioner was under reserve category. My lord, will take page 20 of the my lord, this petition. At serial number 37, my lord, the petitioner was under reserve category, and my lord, for the state of Assam, there was only my lord, one vacancy. So, my lord, the candidate who was selected, my lord, my lord will take page 16 first, my lord. Page 16. That is the state-wise merit list for Assam, my lord, annexure 4. There, my lord, will see the name, serial number 1, my lord, remark column will see, my lord, selected. And then, my lord, for the petitioner, it is mentioned reserve 1. With the marks, my lord, 249.75. Now, my lord, we take page 20. My lord, at page 20, the marks secured by the petitioner at serial number 37. My lord, this is on the reserve category.
Yes.
My lord, at page 20, serial number 37. My lord, will see the marks secured by the petitioner 249.75.
Got it. Got it.
My lord.
Got it.
Reserve. And my lord, will see, my lord, since my lord will see the marks secured by the last reserve category candidate. My lord, if you see serial number 34, as only 34 candidates were called in the order of merit, my lord, the marks secured by the last, my lord, reserve category candidate was, my lord, 254.25. My lord, serial number 34. So, my lord, what happens in the process of selection? First, my lord, from the merit list, the candidates are called and the selection is made. And then, my lord, the reserve candidates are called. And in the reserve category, my lord, under the reserve, my lord, the last reserve category candidate's marks was, my lord, 254, whereas the petitioner, my lord, secured 249. For that reason, my lord, only one candidate was selected from Assam, and he could not, my lord, make the. That is also, my lord, the another reason, because, my lord, 34 candidates only will be selected. 34 candidates will have qualified the medical examination. And, my lord, if you see the merit list, under serial number 34, this is the, my lord, mark secured by the last reserve category candidate. That is 254.25. Whereas petitioner is at serial number 37, much below, my lord. That is at 249.75. So, in order of merit also, my lord, because of that, my lord, he could not make the placement. And so far as vacancies are concerned, my lord, we have categorically made a statement how the vacancies are determined, because every year, my lord, certain ratio has to be maintained. And the students which pass out every year, in accordance to that, my lord, and there is, my lord, I have taken instruction, my lord, that there is a specific order to that effect also. If lordship calls for the record, my lord, we can produce the record also as to how the vacancies, when was the decision taken to vary the vacancy. And I have taken instruction.
Is it necessary?
Well,
to produce the documents?
Before that, my lord.
I can produce the record.
Before that, my lord. Well, page number 20, as my learned friend is showing, my lord, serial number 34 and 37, this is the merit list prepared after conclusion of written test and viva voce, not after medical test. Because out of these 44 students who were called for medical, 10 dropped and 34 qualified. So showing the 34 serial number is so and so, probably, my lord, I fail to understand that, my lord. Because this is regarding the merit, my lord. Merit after. Merit list they have prepared after written and viva voce examination. This is the list. Then these students were called for medical examination. Out of 44, 34 students have cleared medical. Now the merit who has completed all the 3 rounds of students, that will be counted by the finally. if I'm correctly understood, my lord, the position, the merit list of the students who have finally examined cleared all 3 rounds of examination will come into effect. Now that list they have not prepared. They have not produced anywhere. They have prepared, they have not produced, not floated anywhere. That is why in page 41, as I have shown to your lordships, that documents, along with this, when this decision was taken, that 28 seats are available because they have, for the first time in this petition while filing of affidavit, they say yes, there were 28 seats. Prior to that, they have none. Nowhere they mention, nothing. Even we have written to them before filing this petition. Kindly clarify how many seats are there. Is there any variation? We have enclosed this annexure 1 document also. This was you floated, and how many seats? They have not answered. Only first time while filing this, we have come to know that there were this time 28 seats are to be filled up. If that decision was taken prior to that, well, there ought to have been some transparency, my lord. They ought to have filed it, floated it in their website. There is no scope for us to file this petition. If you are not in the queue of merit list, we will not file it. But you will say that there are 36 vacancies. You will not reply to anything. Now, when we say that we stood at 31, why you are not calling us? You called up to 30. Next is my turn. Then they say, no, only 28 will be admitted. And my lord, this list, what they say from Assam, only one selected. Lordship may kindly turn. They have admitted this list at page 8 of my writ petition. I'll show to your lordship. Page 8, relevant will be page 9, my lord. I have given the name of the students who were called for. Now, my lord, at serial number 5, this is one student from Odisha. Has your lordship got it?
Got it.
This is selected category on the right hand side. Now, lordship will kindly turn to the next list at serial number 6. This is also from Odisha. He is from reserve category. Because for Odisha, one seat was allotted. Similarly, serial number 7 on the top list at the Daksha Sagwan. This is from Haryana. He is from reserve category, not selected category. He was first called. Now, lordship will kindly turn to serial number 7 of the next list, down below list. He is also from Haryana. He is from reserve category. Probably from Haryana, none was selected, or the selected candidate could not clear the medical test. Probably. I'm not sure. That is why 2 students. If lordship comes to annexure 1 for Haryana, there is 1 seat. For Odisha also 1 seat, and for Rajasthan also 1 seat. Lordship sees Rajasthan, there are 2 students. Rajasthan on the top of the list, serial number 8 is from Rajasthan selected. Serial number 11 is from Rajasthan reserved. So there are instances you are giving admission to reserve category. Reserve means waiting list. If all are selected, 36 selected candidates you are admitting, then reserve will have no chance. Now, there are vacancies. You are not calling us. And at page 41, I say that my completion of the medical examination, I stood at 31. You have called up to 30. Now, still there is 1 vacancy. Why I say so, my lord? I have instruction to say now in that page number 9, my lord, this boy.
Yes.
My lord, the second list of page number 9, serial number 3, Devans Misra. He is from Madhya Pradesh, reserve category. He took admission and he has left. This is to my instruction, my lord. Today morning, I got this instruction that his father has also written a registered letter and mailed to the authorities that he will not continue. So thereby there are 20. That's why, my lord, I was submitting that there are 20 students they are pursuing, 1 left. Earlier 28, 2 did not continue. They have called another 2. Up to 30 in the final merit list. I stood at 31. Now again, this Devans Misra is not continuing. He has sent a mail. That document is not there. Lordship if lordship is calling for the records, these 2 records also may be called for. The final merit list after completing the medical examination, when the decision was taken that 20 seats are going to be filled up, second instruction, third is, my lord, the list of students who were called and how many are continuing till now. If I stand there, my lord, in a very limited scope, this boy.
Yes, Mr. Gupta.
My basic submission, the list, my lord, at page 19, which is the All India merit list. my lord, this is in order of merit. Selected candidates' marks are in order of merit, and my lord, reserve category
no,
marks.
his submission that Mr.
One has left.
Devans Mishra
My lord.
of Madhya Pradesh, he already left the institution.
Yes.
So if
That instruction I
if
can-
one postage seat is lying vacant, then can he be accommodated there?
That I can take instruction on, but subject to, again, he has to come on merit, my lord, because as I told my lord that the reserve category candidate last, my lord, even if you take serial number 36, my lord, presuming that 36 seats have to be filled. Last reserve category marks is, my lord, 250.60. And my candidate has secured 249.75. Now, my lord, as per my instruction, 28 seats, already admissions seats are full. They are, as per my instruction, 28 students are studying, my lord. Already they are studying.
No, his instruction is recent.
Out of that 28 students, one. Out of those 28 students, one left. Then that thing I'll take instruction, my lord. Whether after admission, if he has left. My lord.
So, can we release the matter on Monday?
My lord, my lord, my lord. 38. Yes, yes, my lord. Yes, my lord. I'll take instruction.
And also, my lord, final merit list after medical examination, that they have not produced, my lord. That can be.
I'll produce it.
Okay. Both the parties are duly represented by the this council. After hearing learned advocates of both the parties, it is provided that Mr. Gupta, learned counsel for the respondent, number 1, 2, 3. Shall obtain necessary instruction as to whether any post is lying vacant. No, any seat is lying vacant. And also the final merit list. Final merit list on Monday, next Monday. Recessal is the matter.
On 30. I'm deeply obliged. For bail hearing, item 18.
Did he receive lordship? Actually, the lordship. I forwarded to BNR application seeking previous bail of the petitioner lordship. The matter relates to the cancellation of the FIR you also will find a page 13 of the particular lordship. Page 13.
So, you received the case diary?
He received lordship, but one thing is that lordship, statement of that driver has been recorded lordship, and who was carrying the driving the vehicle lordship. And as per his statement lordship, 2-3 numbers were in contact with him during the transportation of the cattle. 30 numbers of cattle were connected.
No, you tell me, is there any material of section 307? IPC?
Lordship. What happened lordship, after seizing that vehicle, stop that vehicle lordship, the one vehicle is escorting that cattle lordship. And when the police tried to stop them, they hit them per lordship, and one person injured lordship, he has been sent to medical lordship, but that medical report is not available, and along with that CDR is also not available lordship. So I pay for some time lordship for that lordship. I have contact with the OC on the concern lordship, and he has also requested me to take some time so that they can produce.
Okay,
that
then next Monday?
Monday lordship. Tomorrow is also holiday lordship, so can it be on 3rd lordship? It will be
3rd.
lordship.
Heard Mr. Sutia, learned counsel for the applicant, and Mr. Yes, your good name, please?
Yes, Lord.
Yes, Lockhart, learned counsel for learned additional PP. Mr. Parasar, Mr. Lockhart submits that he has received the case diary, but the medical report and also the CDR is not available in the case diary, and price for granting him some more time. Here is allowed. Recessal is the matter on Tuesday.
On 3rd September. Item 42. Item 42.
Did he receive lordship?
In this case,
other co-accused, my lord, serial number 4 and 1, my lord, of the affair, they are granted pre-arrest bail, my lord. One from this honorable court and another is for coordinated bench, my lord. Petitioner is told not.
This is the second application.
Yes, my lord. A petitioner only they.
So what is the ground for filing this second petition?
Yes, my lord. Page 6, my lord, para 7.
No, the fact is that one Padmakanto Soikia is granted PRS bail. It does not mean that the present petitioner has also to be granted the PRS bail. That is depend upon the materials available in the case.
Another is, my lord, Padmakanta Soikia and Padmakanta Sharma. One Padmakanta Sharma, one is the Padmakanta Podumi Sharma, my lord. Serial number 1 and serial number 4 of that family. My lord, the petitioner is the only deed writer, my lord. And he does not know who has registered.
Yes, Mr. Locker, what is there in the case area?
So this person is involved in the allegation, lordship, and lordship. But actually, in this case, lordship, the main seller died, lordship, 24/12/2019, and the deed was executed on 2/3/19, lordship. And some witnesses statement has been recorded, lordship, wherein they have stated, lordship, they have also seen this petitioner.
Whether investigation is completed?
Not completed. And his involvement in the lordship, the witnesses specifically stated, lordship, that this person was present there. They has to ask him that where is that seller, lordship. Then he told that nowadays these sellers are not required to be present. There is some new method has come out. That is why these are against him, lordship. And the co-accused has also stated, lordship, he has some dealings with this person, lordship.
The rule of the petitioner, my lord, only to drafting the sale deed. The rule of the petitioner only drafted the sale deed, my lord, and handing over to the purchaser or seller, my lord. And he does not know who produced the sale deed before the registry, and registry is executed the sale deed, my lord.
As per the statement of the witness, he was present during the registration, lordship, and he has stated, lordship, that after the death of the sellers,
he is present, he is involved, my lord. He is present before the registry or other authority, my lord. It does not mean that he is involved in the crime, my lord. He has the purchaser, not seller, my lord.
He is the middleman. That's statement. That is statement that you and the next statement. This statement.
Mr. Lokor, let Mr. Ahmed go through this statement. Or Mr. A.M. Ahmed, learned counsel for the applicant, and also heard Mr.
Yes, Lord.
P.S. Lokor, learned additional people for the state respondent. Pending arrest in connection with Kanpur PS case number 127 of 2023 under section 120B 420 468 471 IPC. This application under section 482 of the BNSS 2023 is prepared by applicant Ramkrishna Soikia for grant of period pay. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Diganto Kumar Goswami on 21/7/2023. The gist of allegation in the FIR dated so is that his father, late Prabhat Chandra Goswami, died on 24/2/2019, leaving him and other legal heirs. But unfortunately, 5 cell leads were registered in the office of the sub-register, Kanpur, after the death of his father, practicing fraud in the name of his father with the help of scribe, witnesses, identifiers of the cell deeds in respect of the land belonging to his father. And the purchasers were Krishna Lokor, Krishna Kanta Bora, and Padmo Kanto Soikia. Mr. Ahmed, learned counsel for the applicant, submits that this is the second 3 years bail application prepared by the applicant, and the first one being AB number 3546 of 2023 was dismissed by this court by the order dated 18/10/2023. Mr. Ahmed, learned counsel for the applicant, further submits that while dismissing the earlier 3 years bail application, this court has not considered that one of the person, namely Padmakanto Soikia, alias Padum Sharma, alias Padumi Sharma, has already been granted PRS bail in AB number 3499 of 2023 and AB number 3893 of 2023, respectively. And the present applicant is also stands in the same footing, and he is also entitled to PRS bail on the ground of variety. Mr. Ahmed further submits that after rejection of the earlier bail application, on a PRS bail application, the investigating agency got sufficient time to investigate the case and arrested the main accused, namely Krishnakanto Lokor, along with Nipian Hazarika. And they were also released on bail later on by order dated 18/10/2023 and 1/8/2024, respectively. And that the applicant is not involved with the offense alleged, and his name has been raised by his rival parties, and there is no incriminating materials against the applicant, and that except drafting the deed, he has no role to play, and therefore Mr. Ahmed submits that the privilege of PRS bail may be extended to the present applicant also. On the other hand, Mr. Lokor, learned additional PP, has produced the case diary before this court and submits that investigation of the case is going on, and the IO has collected sufficient incriminating materials against the present applicant, And besides being a scribe, he also played the role of middleman in execution of the sale deeds, and that the grounds so assigned for filing this second application is also not maintainable, and therefore Mr. Locker has contended to dismiss the petition. Where having heard the submission of learned advocates of both sides, I carefully gone to the petition and the document. Then also peruse the case diary with the assistance of Mr. Locker, learned additional PP. The case diary indicates that the IO has collected sufficient incriminating materials against the present applicant, and the same has duly been reflected in the order dated 18/10/2023 in AB number 3546 of 2023. It is, however, a fact that some of the co-accused have already been extended the privilege of peerless bail and also granted regular bail after their arrest. But it is well settled that the ground of parity, the benefit of peerless bail on the ground of parity cannot be extended in a routine manner, and it has to be seen what role the applicant has played in commission of the offense in respect of the and also in respect also by the other accused persons. In the given facts situation, and also considering the submission of learned counsel for both the parties as well as the materials collected so far in the case diary, this court is of the view that the ground so assigned for filing this second application is not at all maintainable, and also in view of the materials and the role played materials collected against him and the role played by him in commission of the aforesaid offenses, the privilege of peerless bail cannot be granted to him at this stage, and therefore the petition is thus dismissed. Case diary will return.
It is for hearing under order 41 roll to CPC. Item number 19. May please, ma'am. Madam, the second appeal is, madam, directed against two concurrent findings, madam. I have given the genealogy, madam, that would help. Genealogy, please. Madam, initially one Moharam Ali, the petition to the interest of the present applicants, he was the absolute owner of 3 bigha, 1 kotha, 3 lessons of land. That is the Schedule A property, madam. He died in the year 2007, madam, and thereafter, his wife Halima Khatun, his two sons, Basiruddin and late Rohimuddin, their names were mutated and they became the absolute owner. Halima Khatun also expired and Rohimuddin also expired, and thereafter the legal heirs were brought on record, madam. The present appellants, madam, they filed a suit seeking a decree for declaration of right title interest, recovery of possession, and permanent injunction against the present respondents as defendants. Now, my case is that, my lord, after this 3 bigha, 1 kotha, 3 lessons of land, Halima Khatun and Rohimuddin, they sold 1 bigha of land out of this 3 bigha, 1 kotha, 3 lessons to the respondents. That is the defendants. That is the Schedule D property, my lord. And thereafter, my lord, 2 bigha, 1 kotha, 3 lessons of land remain in our possession. That is the Schedule C land. Now, taking the advantage of, my lord, while one point has to be noted, my lord, while executing the sale deed in favor of the present respondents, the northern boundary of the sale deed was given wrongly, my lord. that I have stated in my plain ballot will find at page number 19, my lord. Last line I'm reading, my lord, second last line. Plaintiff number 1 and late Rohimuddin during his lifetime sold a plot of land measuring 1 bigha of the Schedule A plot of land to Mosaddar Ali, that is son of Hafiz, that is the predecessor interest of the present respondents, by sale deed number 2516 of 81 dated 19/3/81. It is mentioned here that in the above mentioned sale deed, the boundary of the scheduled plot of land measuring 1 bigha was wrongly mentioned as follows: North Ismail Ali, South Atawar Rahman, East Ayub Ali, West Road. This northern portion was wrongly given. Instead of Ismail Ali, my lord, I have given in the next paragraph, North, the land of plaintiff should have been given, my lord. That was mistakenly given and that remained, because even we are not very acquainted with the niceties of the law, and that remained and no rectification deed was filed, my lord. So that, taking that advantage, my lord, in the year 2015, my lord, the present respondent, they encroached upon 1 kotha 10 lesas of land out of the Schedule C plot of land. So in the Schedule C plot of land, I'm seeking declaration of right title interest and recovery of possession. That is my suit, my lord, that I have been dispossessed from 1 kotha 10 lesas of land out of the Schedule C plot of land, and that recovery of possession should be given to me. Now the learned trial courts and the first appellate court held that, my lord, only on one ground, that since the boundary of the sale deed that is shown in the northern portion, my boundary is not there as is reflected from the sale deed. So, my lord, it cannot be held that 1 kotha 10 lesas of land belongs to me and there is any encroachment by the respondents. And that 1 kotha 10 lesas of land is also not identified. That, my lord, will find at page number 101. Para 35. May I read, madam? Before deciding the right title interest of the plaintiffs over the suit land, that is 1 kotha 10 lesas described in Schedule D, it is necessary to determine whether the defendants constructed RCC structure on the said suit land by exceeding their 1 bigha land on 11/8/2015. The description of Schedule D in the plaint is that the Schedule D is part of Schedule C land, measuring 2 bigha 1 kotha 3 lesas. First of all, PW1, that is the plaintiff number 2, admitted that they have not measured the land to know the exact area of land encroached by the defendants. The plaintiff does not even have mentioned about the site from which the alleged encroachment was made. This is perverse because, my lord, in the cross-examination of PW5, it is specifically stated that from the southern side of the Schedule C land has been encroached. Although the plaintiff averred that the land was demarcated by Lot Mondal on 10/12/2015, and the concerned Lot Mondal found that the defendants have encroached 1 kotha 10 lesas of land out of 2 bigha 1 kotha 3 lesas land, but the plaintiff did not produce the report of the Lot Mondal in support of his contention. Thus, the allegation of the plaintiffs that the defendants encroached 1 kotha 10 lesas out of 2 bigha 1 kotha 3 lesas is not based on anything concrete. 36. It is seen that the sale deeds by which late Moharam Ali purchased 3 bigha 1 kotha 3 lesas land does not have mention of its boundaries. Late Moharam Ali purchased said land in parts. It is not mentioned from which part of the said land of 1 bigha was sold to the father of the defendants. This is not even important because, my lord, I have given the boundaries, my lord. Further, on perusal of the sale deed dated 19/3/1981, it is seen that the plaintiffs do not have their land on, this is important, do not have land on any boundary of 1 bigha land sold to the father of the defendants. This sale deed is of the year 1981, and admittedly the defendants are in possession of 1 bigha land as per the sale deed since then. It is at the time of filing of the plaint that the evidence has averred that the boundaries mentioned in the sale deed are incorrect. Without getting the deed rectified, on one hand, the plaintiffs are claiming to have sold 1 bigha of land to the defendants by registered sale deed, and on the other hand, they are claiming that the boundaries mentioned in the said registered deed are incorrect. Plaintiffs cannot approbate and reprobate at the same time. The boundaries mentioned in the registered sale deed, which is proof of identification of 1 bigha of land of which the defendants are admittedly the owners and have been in possession since 1981 by constructing houses thereon, will be the basis for determination of dispute between the parties. Mere pleadings or even oral evidence with respect to the boundaries of 1 bigha land will not prevail over the registered instrument. Now here, for a moment, I'll pause, my lord. I'll just take your lordship to page number 90, my lord. That is the cross-examination part of the DW1.
Okay,
my lord.
we admit a
my lord.
appeal.
My lord.
When the judgment was passed?
Judgment was passed, my lord, on 21/8/2024. And my substantial question of law is at page number 5.
Heard Mr. Iqbal, learned counsel for the petitioner. The appellant. The second appeal, regular second appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 21/8/2024 passed by the learned civil judge, senior division number 2, Kamrup M. Guwahati, in title appeal number 3 of 2020. It is to be noted here that by impugn judgment and decree dated so and so, the learned civil judge, senior division has dismissed the appeal, thereby uphold the judgment and decree dated 30/11/2019 passed in title suit number 223 of 2016, passed by the learned civil judge, junior division number 2, Kamrup M. Guwahati, whereby the learned civil judge, junior division number 2 has dismissed the suit of the appellant. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated 21/8/2024 passed by the learned civil judge, senior division number 2, and in title appeal number 03 of 2020, and also the judgment and decree dated 30/11/2019 passed in title suit number 223 of 2016 by the learned civil judge, junior division number 2, Kamrup M. Guwahati. This second appeal is admitted on the following substantial question of law. Number, whether 2 is required, I don't think so.
2, my lord, perversity, why am I claiming? Because the defendant is acquitted. In the northern part, the plaintiff is there. That part has not been considered by the learned appellate court. Once it is admitted, my lord, facts admitted need not be proved. Section 58 and section 53 of the new act, my lord. So I need not prove anything, my lord. But the court below is held otherwise.
Whether the first appellate court was the first appellate court has correctly rejected the application filed by the appellants under order 41 rule
27, my lord, typographical.
Oh yes. Pardon?
Rule 27. It is written as 47.
Order?
Order 41, rule 27 of CPC.
But you have mentioned it as 47.
47, typographical error. It ought to have been 27.
Order 41, rule 27 of the Code of Civil Procedure. And number 2, whether the judgment and decree passed by the learned first appellate court and also by the trial court are vitiated on account of perversity. Let notice be issued to the respondents, returnable in 4 weeks, as the be taken by registered post with AD and also very well processed within a week from today. Call for the record from the learned first appellate court and also from the trial court. List the matter after 4 weeks.
Well, there is an IA 2948 of 2024. Seeking an injunction.
So immediately, perhaps no execution proceeding. No, question of execution proceeding does not arise.
And execution does not. My suit was dismissed. They are going ahead with construction, my lord, on waterproofing manner, my lord. At page 26, I have given the photographs. And in the trial court also, my lord, there was an order of status quo to be maintained by the parties. That is at page number 25, my lord. So at this moment, I'm praying, my lord, since the subject matter is sub judice, my lord. So status quo should be maintained as was maintained in the trial court and the first appellate court. Otherwise, my lord, the very character and nature of the suit property will be changed. Case number 25, my lord. The petitioner has also prayed for status quo during it is held that the both parties have maintained status quo in respect of the Schedule C and D properties.
So let notice go at this instance.
Until the returnable date, my lord, status quo, my lord. Otherwise, they will go ahead with the construction. Since vacation is also coming, they will complete the construction.
We'll fix a short date.
At least status quo, my lord. I'm not asking for much, my lord.
There is concurrent finding.
My lord, that is true, but an order of status quo was there in the trial court as well as in the appellate court, my lord.
Maybe.
But if the subject matter is changed, my lord, then in execution proceeding again, my lord, I have to will delay the matter.
Let it be fixed on 4th of October.
4th of October. I can take steps immediately, my lord. I'll take steps immediately, my lord. On Monday, I can take the steps. Don't come back.
On?
I can take steps immediately, my lord. By Monday, I'll take the steps. But okay.
Heard Mr. Iqbal, learned counsel for the applicant. Appellant. This application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure, is referred by the applicant stroke appellants for granting temporary injunction. Having heard the submission of Mr. Iqbal, learned counsel for the applicant, and also considering the facts and circumstances on the record, this court is inclined to issue notice to the respondents, returnable on 4th of October. Step be taken by a registered post with AD and also by result process within 2 working days from today. List the matter on 4th of October.
My prayer for injunction may be considered on the next statement.
You served the notice.
Item 20, deeply obliged.
In this case. Hello, the applicant filed a suit. And for title interest and recovery of positions. And I also filed a counter claim. The learned court below, my lord, decreed the suit and dismissed my counter claim. And we filed an appeal that appeal was also dismissed. Very peculiar fact is loss of kindly see. No issue was framed on my counter claim, my lord. If you loss of kindly see the page, appellate court judgment, my lord, page 17. Only 4 issues has been issued. No issue has been framed on my counter, whether my counter claim is maintainable, whether I have the right title interest by virtue of adverse positions. No issue has been framed. A lordship can give the substantial question of law, page 3. The learned court will held that both the court will that the suit is not barred by law. And regarding adverse position, no issue was framed. However, decided that I am failed to prove the adverse positions because I have not mentioned the date when I am in position. But in written statement, I specifically mentioned that from 22 to 2022, we have in position. And that fact has been ignored. Now let's kindly say issue number E and F.
purpose it is there because I clearly mentioned, we clearly established that we are entered position on 222 to 2020, 2002. And that fact has been ignored by the border code below and held that I am not mentioned when I am in position. And in written system, you will kindly see, I specifically mentioned page 76. Written counter claim, my lord. Page 76, paragraph 2, that on 22 to 2020, the defendant took possession of the Y schedule land in my counterclaim schedule, and it is the schedule of the suit. So apparently the court will has overlooked the facts. So now let the notice go. And moreover,
But whether so many
not necessary,
substantial
my
persons
lord,
are-
I just given my lord, C, D, E and F is necessary, my lord. And moreover, I am the appellate court below is a court of facts. It should be pronounced the judgment issue wise, my lord. So I am not raised that point because the learned appellate court should have passed the judgment in view of order 41, rule 31 CBC, but that has not been proved. That is the one of the subsequent question of law. Being a court of facts, he should pronounce the judgment in conformity with the order 41, rule 30, order 41, rule 31 of the CBC. That has not been done. It is very important question. I am left out.
So at the time of hearing that
Yes, my lord.
so will be
Yes,
considered.
yes. The capacity is there. That is why A is
Sir
there.
J. Ahmed, learned counsel for the
A is necessary because capacity is there.
appellant. This appeal under section 100 CPC is directed against the judgment and decree dated 8/7/2024 passed by the learned civil judge senior division Barpeta in title appeal number 56 of 2022. It is to be noted here that by the impugned judgment and decree dated so and so, the learned civil judge senior division has upheld the judgment and decree dated 20th/10/2022 passed by the learned Munsif number 2 Barpeta in decreeing the suit title suit number 104 of 2015. Here is the memo of appeal and the grounds mentioned therein. And also there is the impugned judgment and decree dated so and so passed by the learned civil judge senior division Barpeta. And also the judgment and decree dated so and so passed by the learned Munsif number 2 Barpeta. And title suit number 104 of 2015. This regular second appeal is admitted on the following substantial question of law. 1. Whether the suit whether the learned courts below have correctly decided the issue of limitation as per provision of section 65 of the Indian Limitation Act. And whether number 2, whether cell date number 2571 of 2003, exhibit 3, executed by the seller in favor of the plaintiff is valid without delivering of possession, as the suit land was under the possession of the other person, that is the defendant, at the time of execution of the exhibit 3. Number 3, whether the learned courts below are justified in deciding counterclaim without formulating any issue on the counterclaim. as to whether the appellants stroke defendants have acquired right, title, and interest over the suitland by way of adverse position or not. Next, whether the impugned judgments and decrees passed by the learned courts below suffers from perversity on account of misinterpretation of evidence on record as well as misinterpretation of law and facts in determining the issue. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing after giving notice to both the parties. Let notice be issued to the respondents returnable in 4 weeks that be taken by the registered post with AD and also by legal persons within a week from today. The SSL call for the records from the learned courts below and list the matter after 4 weeks.
I will not press the I at present. I is there, but the execution was not started.
Okay.
So it is kept.
21.
21 also, my lord, Sam, because Sam judgment, one was filed for dismissing declaring the suit, and second was filed for against for dismissal of my counterclaim. Same issue.
Item for orders, item number 22.
None appears for the appellant on call. SSL is the matter after application.
24.
24, your lordship, I am appearing for the sole respondent. Lordship, here this order was issued in a series of cases, lordships. So in the series, in the first case, lordship, the compliance order was issued. But so far this petitioner's case is concerned, lordship, that there was a direction to issue an individual order, lordship. That order may, lordship, I will be given on Monday, lordship, I'll produce it before this honorable court, lordship. Lordship, you can fix it on Monday as first attempt, whatever, lordship, I'll produce it on Monday, lordship. Yes.
Okay. On the appear being made by Mr. SMT Sistri, learned counsel for the sole respondent, having not been objected by the learned counsel for the petitioner, SSL is the matter on Monday, so as to enable Mr. Sistri to produce the what document?
A specific compliance order, so far.
For
Specific compliance order, lordship.
Production of compliance order.
The petitioners are concerned.
Concerning the present petition.
Yes.
Here is allowed.
Obliged to.
25.
May please, your lordship. My lord, the office note is there. LCR has been received. So the matter
Service
is ready
completed.
for hearing.
Service completed.
Yes. My lord. It is against the railway, my lord. Union of India.
No, you have till date not taken any step upon the respondents as per of his note.
Copy was served, my lord, at the time of filing even. The standing counsel is there.
There is no office note.
At the time of filing, we serve the copy. That's the procedure, my lord. Without serving, we cannot file the appeal.
Pardon?
Without serving copy to the railway advocate, we cannot file the appeal. That's the procedure.
No, is that taken?
The standing counsel is there. Always we are serving copy at the time of filing. Formal notice is not issued.
No, it should not be. So there is a specific direction in the order dated 24/7/2024 to take step upon the sole respondent by registered post with AD. And you have not taken any step as per office note dated 5/8/24 and 5/9/2024. You see the office note? Yeah.
Item 26. May it please announce. It's a readmission of the appeal matter, which was dismissed for default on 8/8/24. Opposite party, my respondent, they are supposed to file their objection in the last day.
Malad, I'll just make a few verbal statement, verbal objections. The rest I leave it to Malad. Malad, in my humble submission, the delay has not been explained. The appearance, why the appearance is not there on the dates prior to that as well. Because while passing the order dated 8/8/2024, this court had taken into consideration the fact that the appellant had remained absent prior to that as well on 22/8/23, 14/9/23, as well as 7/12/23. No explanation as regards that point has been provided by my learned friend.
The dismissal was on regarding on 8/8, I was not present, and that was duly explained on paragraph 3, my lord. In fact, my lord, on that day, my lord, I appeared before your lordship after dismissal, and your lordship has advised me to file a proper application. On that day, he was also present.
I was present when my learned
He was
friend.
also present, my lord. Because I was on legs on the another court, my lord, and in the meantime, the matter has been called up and it was dismissed for default.
No, considering your conduct on the previous dates, the appeal was dismissed on that day.
Yes, my lord, I don't know, my lord, what happened in this case, my lord. My name has not been shown even, my lord. Today also, my lord, my name has not been shown in the court list, my lord.
No, you can go and agitate the matter before the registry. Why your name is not reflected?
And in fact, my lord, it's an application under, my lord, for restoration on that day, my lord, on 8/8/2024, my lord. In fact, I appeared, my lord. Immediately after dismissal, my lord, I appeared before lordship, my lord. And he was also present on that day, my lord, and your lordship advised me to file an application, my lord. I was on legs, my lord, that's why I could not appear, my lord. And when they reassemble after the break, my lord, I mentioned this matter, my lord.
Part Mr. Seladityo, learned counsel for the applicant, and Mr.
And Chaudhary.
And Chaudhary, learned counsel for the opposite party. This application under Order 41, Rule 19 of CPC is preferred by the applicant for restoration of RSA number 51 of 2014, which was dismissed for default on 8/8/2024. The learned counsel for the applicant submits that on 8/8/2024, he was on leg in another court and therefore he could not appear before the court, before this court when the item was called. And therefore it is contented to allow the application. The learned counsel for the respondent, the opposite party, however, submits that the appeal was not dismissed only on the ground of absence of the learned counsel on 8/8/2024. It was dismissed also taking note of the absence of the appellant on 17/12/2023, 14/9/2023, and 22/8/2023. And though an explanation is forthcoming for the absence of the counsel on 8/8/2024, there is no explanation for remaining absent on 7/12/2023, 14/9/2023, and on 22/8/2023. In view of the facts and circumstances on the record, it is provided that the learned counsel for the appellant shall file an additional affidavit showing the ground of his absence on 7/12/2023, 14/9/2023, and 22/8/2023. List the matter immediately after reopening of the vacation. Okay, also note down one thing. The learned counsel for the applicant also submits that his name has not been reflected in the cause list. Rest shall do the needful in this regard.
Date may be fixed, my lord.
Immediately after reopening.
27 and 28.
Maybe your lordship, my lord, kindly have a look at the lordship order passed last occasion on 18/9, my lord. IA number, IA criminal number 668, my lord.
Whether any amount was paid?
Yes, my lord.
I have no idea, my lord. No instruction like this.
My lord, to my instructions, my client has deposited 50,000, my lord, in the state bank account of the petitioner, applicant of this IA, my lord, on 25 and 26, my lord. 25th of September, 26th of September.
But just few minutes back, client talked to me, nothing's known like this. Number one. Number two, my lord, 14,000 per month, 11 lakh. This 2018 started, my lord, 2016. And my lord, the present condition of the wife, because of foreseeable termination of pregnancy by him. And
No, Mr. Talukdar, you obtain instruction whether you have received the 50,000 or not.
My lord,
my lord, I have to receive, but my lord, at present, my lord, at least 4 to 5 lakhs.
You first inform this court whether you have received that amount or not.
My lord, maybe take up a few minutes, my lord.
that state bank account number, which has been provided in the criminal petition at page number 146. The applicant's state bank account number, in that account number, we have deposited 50,000, my lord.
My lord, even if it is deposited, my lord, out of 11 lakhs, and now I major operation now, including the girl child who has lost one, are lost because of typhoid and pneumonia, my lord. There, I can kindly have a look with the medical documents I have annexed, my lord. Then your lordship will.
On Monday, you inform this court whether you have received the amount or not. Thereafter, we will see.
On Monday, my
both the parties are represented by their NBS counsel. Mr. Chaudhary, a learned counsel for the respondent, submits that person to order of this court dated 18/9/2024. The respondent has deposited a sum of rupees 50,000 on
my lord, 25th of September and 26th of September.
25th and 26th of September 2024. Mr. Talukdar, learned counsel for the petitioner, submits that he has no instruction as to whether the petitioner has received the amount or not. In view of above, it is provided that recessal is the matter on Monday.
My lord,
so as to enable
one small
Mr.
request, my lord.
Talukdar.
Many times it is last moment. Can it be at 2, my lord? Very urgent, otherwise, my lord. Otherwise, sometimes it also did not reach earlier also on last many occasions.
So list the matter on
Monday at 2 p.m.
Monday at 2 p.m.
Obliged.
So as to enable him to obtain necessary instruction and to apprise this court about the amount.
Standing item 25.
I think the order, my lord, order is there by registered post steps we have ought to have taken. But my lord, as the Deputy Solicitor General of India is here, always we are giving hand-to-hand notice. So formal notice by registered post is not necessary. If still, my lord, order is there. If you
No, you file in that case, you file an affidavit that you have caused service of notice to the Deputy Solicitor General.
After serving,
because without any record, we cannot observe that service completed.
My lord, we will, after handing over the copy to the Solicitor General of India, we will file affidavit. That will comply the order.
Heard, Mr.
J. Mullah,
learned counsel for the appellant. Mr. Ullah submitted that he has caused service of notice upon the Deputy Solicitor General. On which date?
By Monday, we will serve.
No, on which date you have caused service?
No, that copy we served at the time of filing of the appeal, my lord.
At the time
Now,
of filing
yes.
of the appeal?
Yes.
At the time of filing of the appeal, but there is no such record available. No record of service of notice is available on the record. In view of above, it is provided that Mr. Mullah shall serve copy of this memo of appeal. Serve notice with the memo of appeal to the Deputy Solicitor General of India, and thereafter file an affidavit before this court by after. And
by Monday we'll do it.
Okay. After vacation.
Item 29.
May take up Miss case 67 first, 67.
Here, my lord, before my learned friend make the submissions, my name has been shown in the close list, but no copy of the IA and this case has been provided to me. I have appeared in the earlier this case number 38 of 2024, which 23, which was withdrawn by them on 11/9/2024, my lord. One notice they have enclosed showing that I have received. That notice was received.
Now you tell me whether you have received a copy of this application or not.
Today I can receive, my lord. If they provide, I shall receive, my lord. And thereafter I shall file the objection, my lord.
Acha. Okay. Heard Mr. Mukherjee, learned counsel for the applicant, and Mr. R.C. Sansetti, learned counsel for the opposite party. Mr. Sansetti submits that he has not received a copy of this application. Mr. Mukherjee submits that he will furnish a copy of this appeal, no, a copy of this petition to Mr. Sansetti during the course of the day. SSL is the matter on. After vacation, is there any urgency?
Lordship, only thing is that there is an IA as well, and they have initiated execution. This suit, CRP was dismissed for default, and they have filed the execution, and that is pending.
No, but CRP was not dismissed for default. That was dismissed for not taking a step about 7 years, my lord, or for non-prosecution. Thereafter, they filed and in this case for restoration of that money revision. Thereafter, that was also withdrawn by them. And now this present application, as I have seen in the records, is also time barred by 49 days. There is also office note. If your lordship may peruse this case number 67 of 2024, there is the office note that there is delay of 490 days, but they have written one line. Perhaps it may not be required. So under the law, they should file an application for continuation of delay of 490 days. Thereafter, the court will consider whether the delay should be condoned or not. There is the office note, my lord. That's why I am praying, my lord. No interim order may be passed. Let me file my objection.
Okay.
That, then after vacation, you know.
Vacation.
Because the execution is already pending. Because the execution filed by them is already pending.
Who is responsible for the same?
Lordship, we have filed this restoration within time, your lordship.
For 7 years, you slept over the matter?
No, lordship. Actually, the restitution, there was another miscase, your lordship, 38 of
Okay,
23.
next that we will see.
Lordship, a date if possible may be fixed after vacation.
Item 30.
Made to the doctor. It is an application for substitution of legal heirs of respondent number 2. Page number 14. Page 1 4, I have given the names.
When the person concerned died?
14/7.
14/7. He was respondent number 2. Heard Mr. M.S. Loskar, learned counsel for the applicant. This application under Order 22, Rule 4 of the Code of Civil Procedure is preferred by the applicant for substitution of legal heirs of the respondent number 2, who had passed away on 14/7/2022. 2024. Where is the petition? Application and the documents placed on record. Where is the death certificate?
We could not get your lordship. We could not get the death certificate from the other side.
Whether the other side appeared?
Yes, we have served a copy, your lordship.
When?
At the time of filing of this application, your lordship, and the other side is already duly represented, and name is also shown in the court list.
Let notice go at this system.
Notice already. The main case notice has already gone, and
Unless the other side admits that the respondent number 2 died, how can we accept it in absence of any death certificate? That notice be issued to the opposite party by registered post with AD and also by usual post.
there are large number of respondents, your lordship. We already, SK Ghosh is representing the respondent side. His name is also shown in the cause list.
No, in this application. Itu आए तो आदि है लिस्ट से.
We have already served a copy also.
To আছে এটা কিন্তু হেভি কোড সার্ভিস কোড. Itu tuh first time listing. Gitu ya? Bukan nama file bisa. Consent. Ya itu naik. Oh, itu So let us fix it on Monday. In the meantime, you inform Mr. Ghosh. It appears that a notice was served on 29/8/2024 to Mr. S.K. Ghosh, to Advocate Mr. S.K. Ghosh. But Mr. Ghosh is, but nobody entered appearance today. List the matter on Tuesday.
Obliged.
31.
Your lordship, my senior has some medical emergency, so he have to leave. So kindly adjourn.
Okay, as paid for by Miss.
He does.
Learned counsel for the applicant, raises a list the matter on after vacation. After vacation.
32.
May it please your lordship. Lordship, in this case, I am on caveat, my lord, but inadvertently, my lord, notice was not served upon me, my lord, and my name is also not shown in the cause list, my lord. So I feel let my lord come on 2nd, 3rd of this month, my lord, and my learned friend served me the copy and raised to be directed to list my name, my lord, the matter. I filed caveat number 1439/2024, my lord. It was filed on 29/4/2024, my lord.
My lord, I am appearing on behalf of, I have instructions to appear on behalf of respondent number 2, my lord. I'll file my wakalat number on Monday. Can it be on 3rd, my lord, along with MSC? There is another connected appeal, my lord, 350th of 2024.
The problem is that on 3rd of October, we have a lot of cases.
The 4th, my lord, because there is some urgency in the matter, my lord.
What kind of urgency?
My lord, the accident is of 2020, my lord. Till now, they have not paid any amount, my lord. The claimant has suffered 80% paralysis, my lord. He cannot walk, he is in wheelchair, my lord.
Heard Mr. S.K. Dotto.
As the.
S. Dotto, learned counsel for the applicant. And Mr. Lal, learned counsel for the respondent number
1, my lord.
1, and Mr.
As Khan, my lord.
S. Khan, learned counsel for the respondent number.
That is to appear on behalf of respondent number 2, my lord.
Learned counsel, who has instruction to appear on behalf of respondent number 2. Mr. Khan submits that he will be filing his Ukalatnama by Monday. Monday. Mr. Lal, learned counsel for the respondent number 1, submits that he had already filed one caveat, but the same has not been listed along with this application. But it is to be noted here that this application under section 173, second proviso to the Motor Vehicle Act 1988, reduced section 5 of the Limitation Act is preferred for condonation of delay of 77 days in filing appeal against the judgment and award dated 2/4/2024, passed by the learned member MSCT, Motor Accident Claim Tribunal number 2, Kamrup M. Guwahati, in MSC case number 1413 of 2020. As agreed by learned advocates of both sides, recessal is the matter on Tuesday, on 4th of October.
Along with MSC appeal number 350th of 2024, my lord. Same appeal, my lord. Claimant has filed for enhancement. In this case, the insurance company has come for.
Along with MSC appeal number
358, my lord.
358 of
2024, my lord.
2024. In the meantime, the counsel for the opposite parties may file their objection if so advised.
I'm objecting.
43. In this case, there was a delay in filing the appeal. My benefits has appeared for the respondent number 152. And appeal against the quantum. And there is no objection in condoning the delay.
So you have no objection?
Yes, my lord.
What is your name?
Commentary.
Pardon?
Commentary, Your Honor.
You have filed your Ukalatnama here? No.
Pardon me, my lord.
You have filed your Ukalatnama here?
I'm representing on behalf of my senior.
Who is your senior?
Right now, she's busy somewhere. Currently.
Tell her name.
Anjana Gohain Chaudhary.
Anjana?
Gohain Chaudhary.
A.G. Chaudhary. Heard Mr. K.K. Bhatt, learned counsel for the applicant, and Mr. So-and-so, learned counsel appearing on behalf of Ms. A.G. Chaudhary for the opposite parties. This application under section 5 of the Limitation Act is preferred by the applicant, New India Insurance Company Limited, for condonation of delay of 16 days in filing the connected appeal against the judgment and award dated
29/4/2024.
29/4/2024, passed by the learned member MSCT number 2, Kamrup M. Kamrup in MSC case number 173 of 2017. Mr. Bhatt, learned counsel for the applicant, submits that. What is the ground?
The procedure will some from this office to that office also.
Submits that though the judgment was pronounced on delivered on 29/4/2024 on account of observance of some formal official formalities, the appeal could not be prepared in time. And when the appeal was filed on 19 August 2024, 16 days, the period of limitation is over by 16 days. And that the delay is not intentional, rather it is circumstantial, and the same has duly been explained in paragraph number 3 of the application. And therefore it is contended to condemn the same. The learned counsel appearing on behalf of Ms. A.G. Chaudhary, learned counsel for the respondent, submits that respondents have no objection in the event of condoning the delay of 16 days in admitting the connected appeal. But having heard the submission of learned advocates of both the parties, I have gone through the petition and also the statement and averment made in the paragraph number 3 of the application. It appears that the delay of 16 days occurred in obtaining suggestion from the High Court panel advocates and also in obtaining approval from the regional office, from the head office at Mumbai. And the same is not intentional. And therefore this court is inclined to allow this application. The delay of 16 days in filing connected appeal stands condemned. In view of order passed in this IA, rest shall register the appeal and put up the same before the court.
24. Listed for the first time, notice maybe insurance.
This is for what purpose?
Delay. In
How many days?
22 days.
Heard Mr. K.K. Bhatt, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred for condonation of delay of 22 days in filing the connected appeal. Where is the application? Let notice be issued to the respondents, returnable in 4 weeks, that be taken by register post with AD and also by result process within a week from today.
Okay. 25.
This is the lordship. But this IA has been filed for condonation of delay preferring the connected appeal. Dated 16/7/2022.
How many days?
670 days, madam.
670.
Yes, madam.
Okay, let notice go.
Madam.
43.
May please, Lordship. My lord, I have filed an injunction petition, my lord. Yesterday, your lordship directed us, both of us, to submit some photographs regarding the construction of the house. And my lord, I need to be allowed these photographs, color photographs. In my petition also, I have annexed two photographs, my lord. That's I have given again.
Lordship, we have also filed to set up photographs showing the old house and the renovation. It clearly shows that it is under the old house was underwater. In the second photograph, it is seen that it is underwater, the entire area, residential houses.
In my photographs, my lord, latest position, photograph number 4 and 5. The newly constructed. Absolutely new construction, my lord.
No, Mr. Day,
Nay, my lord.
you see the photographs submitted by Mr. Bhagawati, especially this photograph
Lordship, underwater.
underwater.
Yeah.
And Mr. Day,
My lord.
it also appears from your photographs that the foundation was old.
Foundation,
This RCC foundation.
my lord, during the pendency of this second appeal, my lord, they have constructed. My second appeal was filed in 2017.
You see the photographs, can it be said that it is newly constructed?
Newly constructed, my lord, recently I have stated in my petition. From construction started, my lord, in 2000 July. July
And
2024.
also see this photograph, can it be expected to live
My
in
lord,
such
those
a house?
photographs I have many years back, my lord.
Many years back?
Yes. Those situations are not there. This is the old, in my photographs, my lord, kindly see that the old house is also there, the sign in the nearby, newly constructed house. That was there, my lord. There is no water logging, but this construction is completely new, my lord. Recently constructed, still it is not finished, my lord. It's still going on. Still going on. So at this stage, my lord, during the pendency, they should not proceed further construction, my lord.
My submission before this honorable court will be, their schedule does not show any constructions. But the photograph says that there is a construction, people were living there. Now, as per order 39 rule 1 and 2, what are the causes under which injunction can be granted? Cases in which temporary injunction may be granted, where any of the suit is proved by affidavit or otherwise that any property in dispute in a suit or in danger of being wasted, damaged, alienated by the party to a suit or wrongfully sold in execution of a decree, or that the defendant threatens, intends to remove and dispose of his property in view of defrauding the creditors, that the defendant threatens and disposes the plaintiffs and otherwise cause injuries to the plaintiff in relation to the property in dispute in the suit. There is no changing the nature and character. No, there is nothing.
Yes, it is changing the nature and character.
This is not a case for
title suit, my lord.
Now here is a case only renovated. It is admitted that
How
it
it
is
is
suit
renovated?
It is admitted it is a suit property.
Clear picture, my lord, whether it is renovation or new construction, my lord.
So there is not an author is that board the decree has been stayed by this honorable court. It is only a suit for specific performance of contract.
Yes.
Tomorrow, if our appeal is allowed, his specific performance will go. Therefore,
Lord, there is a
we should be
concurrent
allowed
finding.
to
Both
stay in
the
a better
courts
way.
decided the
It
matter
should be
in
allowed
favor
to
of
stay
me.
in a better way. Mother is an old person and one of the physically handicapped girl is there.
No.
Mother is an old person.
Who is physically handicapped? No, so far my information is there no person is physically handicapped. Yesterday I have talked to my client.
Go to all controversies. The only thing we have
false submission.
I have not.
And his mother is also very active now. And he is my lord petitioner, so the employee of railway employee.
Be decided in the then let the appeal be decided. We'll see. Now what happened in the recent Supreme Court judgment, it has been shown that the money was given only for the purposes of the loan. When it was loan or advances, thereafter the condition was that if case you fail to repay the loan, then you will go for sale of the land. So in that case, the landed board the courts below should have first tried for whether that person is in a position to pay that amount or not. So the judgment is that when the plaintiff is in advantageous position,
Finding
he
of
cannot.
fact, my lord,
So
concurrent
my
findings
suspicion
are
is
there.
that this concurrent finding, all right, this honorable court has certainly admitted the appeal, therefore there is a ground for appeal. And this court will decide when the matter comes up for hearing, not at this stage now.
Since 2010, my lord.
It is an
Since
ancestral property,
2010,
only property. This
dispute is
whole-
going on.
whole family is residing there.
And both the courts below decided the matter in favor of the plaintiff, respondent hearing. And now at the appellate stage, when he got the appeal is admitted and its execution was stayed by this honorable court, they are raising construction. What is their intention, my lord? They are intentionally changing the nature and features of
Where is
the disputed land, my lord.
Where is the execution proceeding you have given before this honorable court? Where is the execution proceeding?
You have got the stay on that ground.
Right, that is why.
On
Why
that
did you
ground.
submit wrongly? Oh, why did you give a wrong
And
submission
by
before
dint
this
of
honorable
the
court?
stay of the, my lord,
Lordship, it is
impugned
only
order,
bamboo
the
construction.
decrees.
It is only bamboo
They are
construction.
proceedings
and
the
water logging.
construction, my
We
lord.
only wanted to leave it
Just
better
to
way.
change the nature and features of the
No,
disputed land.
and
So that they can raise new points subsequent.
question of nature and changing the nature and character does not, this is not a ground for injunction.
Why not?
It is see, this is the order to read order 38, order 38 rule 1 and 2.
You are damaging the suit land because all
It is not
all
damaging, we
the
are
courts
improving the
decided
suit
the
land.
matter in
We
favor
are
of me.
improving the suit
I
land.
have legitimate right that
It is
I
not damaging, we are improving the suit land. Lordship, my
I
submission.
have already accrued the legitimate
is so
right
much
due
interested,
to
let the matter come up for
concurrent
hearing.
findings of the honorable courts below. At this stage, whether they can proceed for construction, my lord,
We have not.
till the appeal is decided.
Mr. Day, you see the photographs of this. Can person live in this condition?
My lord,
This photograph you see,
their photograph, my lord.
yes.
Their photographs is not numbered, my lord. Which this is all old pictures, my lord. These old photographs. Latest photographs I have given, my lord. Latest. This is my latest photographs, whatever I have submitted. Yesterday I have collected.
What basis you were submitting that this is all photographs?
My lord, flood is, water is there, my lord. There is no water logging. There is no, and it is also, can be seen, my lord, the situation is, my lord, in my photograph, that is photograph number 5 in my photograph, my submitted photographs. My lord, kindly read the side house, that is Assam type house, and nearby the newly construction house. There is no water logging, my lord. Sometimes from which they have collected this photograph, my lord, I don't know, my lord. In which year this photograph is, I don't know. But latest photo, yesterday I have collected this photograph as per direction of this honorable court, my lord. These are old photographs, my lord. Old photographs.
That is the fact. Old photographs means we are living in that condition. That is why we wanted to do some repair works.
No, there is no water logging, my lord.
Recently
it is developed. Subsequently, they have
Neither key
developed
went
and
to that place, nor
residing
I
in
went to
a
that place. Photograph
quiet
is-
manner, my lord.
Photograph only has showed the correct position of this.
When this photograph was,
even otherwise
Well,
also
it is
was-
so old photograph, it seems to me.
Exactly, it is old. That is why it shows. That is why we
No,
have
no,
done
no,
some
you are
repair works.
constructing newly. My contention is that in July you have started the construction. July there is no water logging, my lord.
In Assam, July, there is no water logging. In Guwahati, there is a water logging. You are talking about there in that place. Water logging here, whole buildings collapses because of water logging.
By taking this plea, you cannot change the nature and feature during the pendency of the appeal, second appeal.
All right, let the appeal be. Why don't you agree for that appeal that let the appeal be heard on merit?
Yes, appeal will be heard in moment. I have no objection, my lord. But during the pendency, why they are constructing, my lord? Let them wait for some days. Till the appeal is disposed of.
Mr. Day, this is not permanent construction. It appears to be this torza bear, this thing.
My lord, the foundation
Foundation,
Over foundation, it is Assam type.
Yes.
Floor is a Kacha one. Lordship, the floor is a Kacha one. Only the foundation is big, little bit big. Otherwise, water is going there inside the home. That was only that. The whole house has been renovated to that extent. Only the foundation has been brick foundation has been given without flooring. Complete flooring.
Otherwise, my lord, if it is not stopped, subsequently they will made out a new case that there is a house, Pakka house, it was not there. We describe in the.
That means he
So
agrees.
many
that
things will
does
come,
not
my
contain
lord.
all sorts.
So many things will come, my lord.
We'll finally hear the appeal.
My lord.
Finally hear the appeal.
And in the meantime, my lord, further.
Lordship, we are not going to construct anymore. I can give an assurance to the Honorable Court, whatever construction, because they are very poor people, they could hardly afford to do such these much. Only one person is employed now out of 5 family members. Oh, he is a sepoy in Railway Protection Force. How much he earns?
All are major, my lord. There is no minor. All are incoming, my lord. All are major. Kindly see that their
Majority does not perceive that he is employed one.
Okay, we will start hearing from October 22nd.
October 22nd.
So we will not pass any order in this IA.
My lord, the status quo as on today, my lord. That can be, my lord, pass.
As on today, Mr. Bhagavati has assured that
we are not going to do
there will not
subsequently,
be any.
my lord, he is
no, lordship.
That may be recorded, my lord.
That much of dirty practice we are not going to do it. I can assure the Honorable Court, we have already told, don't do anything because otherwise it is under judice matter.
My lord, that may be reflected in the order.
Okay. Heard Mr. Day, learned counsel for the appellant, and Mr. Bhagavati for the respondents. Recessal links this appeal for final hearing on 22nd of October. In IA, you take down person to order of this court dated 26/9/2024. Mr. Day and also Mr. Bhagavati has produced some photographs of the suit properties. Mr. Bhagavati, learned counsel for the respondents, submits that there shall not be any further construction in the suit properties till disposal of this appeal. On the assurance given by Mr. Bhagavati, learned counsel for the appellant, this IA stands closed. The photographs submitted by learned advocates of both the parties shall be part of the record.
45. IA for condemnation of delay, my lord, of 709 days, my lord. At this stage, my lord, notice may go to. Okay, my lord.
Okay. Quality লাগিছে না এটা সেকশনত কবচোন এটো হেৰি কৰিলে no এটো ফৰমেট এটা বনাই লৈ কম্পিউটাৰত এটো প্ৰিন্ট আউট উলাই দিলে হ'ল এইটো টাইপ কৰি আৰু ইয়াতো ধৰক এই ডেট বিলাক যে লিখি থাকে ইয়াতে এখন কাগজ এখন লগাই লৈ চিৰিয়েলি দি গ'ল
এইটো জায়গা থাকে বেঞ্চে নোৱাৰ আগে মানে সিহঁতে এইফালে গৈছে ইমান কৈছো সিহঁতক কেনেকে ইয়াত লিখিব না নিলিখে আৰু
এটা হেৰি কি জানানে এইটো দেখিছে নহয় এখন আপুনি বান্ধি দিলে এটা কেছটো নাম্বাৰ কি হেৰি কি নাজানে আনলেছ আনটিল এইটো আপুনি চাই এইটো চকুত পৰা কি এইটো
Item 45 by VC.
My lord, may please. My lord, this is an application for condemnation of delay which we filed in support of the LA appeal, my lord. My lord, our case is that this matter first, my lord, what happened is that the land acquisition takes place and a compensation of 60,000 was determined and paid, my lord, for the construction of a substation in Biswanath Sariali. Now, the previous landowners, they approached this honorable court, and this honorable court, my lords, remanded the matter to the EDJ for, my lords, recomputation of the compensation. We were not a party to this particular petition by which the matter was remanded back, my lords. Subsequently, before the EDJ also, in the proceedings for enhancement of compensation, my lords, we were not a party. Subsequently, by a judgment of my lords 4th of March 2024, the compensation is enhanced. And the corrected, my lord, there's a correction application which is filed and that is disposed of by an order of my lord 6th of April 2024. My lord, we were communicated about this order for the first time. I have placed that order as annexure 1 to the application for condemnation of delay, which is IA number 3029 of 2024. My lord, please kindly take that application 30294 of 2024.
Yes.
My lord has that. Now, my lords will directly come to annexure 1, page 17 of this particular application. This is from the district commissioner to us, and the date, my lords, will note at the top right hand corner is 1st of April 2024. This states that there was a case which happened before this particular, my lord, it is mentioned, my lord, the case number is mentioned, LA case number 1 of 2019, and the effective order is also, my lords, quoted, and then it says that please take necessary action. So our case is, my lords, this is the first time that we get to know that this particular, this entire batch of petitions went before the ADJ and this particular order is passed. Subsequently, my lords, another order which is at annexure 2, page 18, is sent by the lawyer, my lords. This is 13th of May 2024. So pursuant to this, my lords, we made inquiries regarding at both places, the High Court as well as before the ADJ, my lords, the court of the ADJ. We were able to procure the papers and then, my lords, we filed this appeal before this honorable court. So my respectful submission is, my lords, we were not heard, even though, my lords, there was another pertinent fact is that before the ADJ, my lords, the proceedings for the enhancement of compensation, there was an application filed for our impediment. That application was never decided, my lord. We have put that, my lords, that's a separate argument for the appeal, but today only the application for condemnation of delay is listed, my lord. So that delay, my lords will kindly issue notice or condone the delay, because what's happening, my lords, is that the execution case has also, my instructions are that the execution case has also been filed. So there is an issue of stay involved and an urgent stay will require. So that I will obviously argue when the appeal is taken up for hearing, my lords. Today it's only for the condemnation of delay.
So let notice go at this, is it?
My lord. And my lord,
Your good name?
my lord CP Shalom.
CP Sharma, learned counsel for the applicant. And Mr.
Okay, but Acharya, I am appearing for a respondents 2 and 3.
Respondent number 2 and 3. This application under Section 5 of the Limitation Act is preferred by Power Grid by the applicant, Power Grid Corporation of India Limited, for condonation of delay of 63 days in filing appeal under Section 54 of the Land Acquisition Act 1894 against the judgment and order dated 4/3/2024, corrected subsequently on 6/4/2024, passed in Miss Land Acquisition Case number 1 of 2019 by the learned Additional District Judge Vishwanath Sarial. Whereas the application and the documents enclosed therewith, let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process upon respondent number 4 to 30. 4 to 30?
30.
4 to 30.
They are private respondents, Lordship.
4 to 30. By registered post with AD and also by usual process within a week from today. No formal notice is required to be issued.
Respondent number 1, which is the power department, separate notice has to go. They have not served notice to, they have only served notice to government, state of Assam. Power is a separate.
Okay, all
They
right.
have standing counsel.
Okay. No formal notice is required to be issued to respondent number 2 and 3 since Mr. Bhattacharya appeared and received notice on their behalf. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks.
I'm obliged, my lords.
Highly obliged.